Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning, Your Honor.
Good morning.
Good morning.
All right, good morning. Before I call the first case, I want to introduce the panel. To my right is Justice Vicki Henry. To my left is Justice Chauncey Wood. My name is Ariane Vuono. I think everybody here knows the rules of the appeals court. Each person has 15 minutes to present their argument. You can be confident that we have reviewed everything that you have submitted to us in connection with your briefs today. So we know the case well, and you can get right to your most important points. You need not use your entire 15 minutes. It's perfectly reasonable not to, but you won't have more than 15 minutes, and there is no rebuttal in the appeals court. So with that, we have 6 cases on for today. 1 case has been removed, and we will likely take our break after the 3rd case, not the 4th, but the 3rd case. And the first case on the list is Commonwealth versus CLAUDIMY LESSAGE. I hope I'm pronouncing that correctly, LESSAGE. Okay. 2024-0932. Counselor?
Good morning. May it please the court. Lindsay Cantor for CLAUDIMY LESSAGE. This is a trial rife with significant errors, most of which are conceded by the Commonwealth, and any one of which merits reversal. What we really see here in this record is sloppiness in the charging decisions, in discovery, in making a clear record about the disposition of count 1 at the first trial, presentation of evidence, in argument, and in instruction. As a result of that sloppiness, Mr. LESSAGE stands convicted of a crime for which he never should have been retried. So I'd like to focus first on the prosecutor's burden shifting and the court's missing witness instructions. The Commonwealth correctly concedes that the missing witness instructions were unfounded and should not have been given. But the Commonwealth's briefing ignores the ADA's highly improper and prejudicial burden shifting and the disproportionate prejudice that accrued to Mr. LESSAGE from these so-called dueling instructions. The Commonwealth has a right to present a fair trial, and that's grounded in the rules of evidence. But the defendant's right to a fair trial is grounded in our Constitution, these fundamental bedrock principles, presumption of innocence and the burden of proof beyond a reasonable doubt. Those 2 things are not equivalent. Now, the Commonwealth argues that defense counsel's argument here came close to the line. I would say it stayed on the proper side of the line, but irrespective of that, even if with respect to the complainant, to referring to the complainant not appearing, it did cross the line. The the court's response was really wholly inappropriate, even if there was improper argument by defense counsel.
Do you mean the judge's response to the missing witness instruction by giving just a general instruction that closing arguments are not evidence? Is that what you're talking about?
No, I'm talking about the court's, so the first thing that the court did,
Okay.
I was going to go there.
Let's break it down to
yes,
what,
the first thing that the court did was sua sponte, was call the parties to sidebar and invite the prosecutor to burden shift in his argument. She said that defense counsel made an improper missing witness argument, and that as a remedy, the prosecutor was going to be allowed to argue that these witnesses were equally available to the defense and that the defense could have called them. The witnesses they're referring to are his accusers, the complainant and the 911 caller. Mm-hmm. And the prosecutor did make that argument, impermissibly shifting the burden to Mr. LESSAGE. Now, what
if the judge had not said anything, all right, and the prosecutor responded to the defense counsel's argument by saying what was said here, these witnesses were available? Is your argument the same?
My argument would be the same. I mean, here we have the court doing 2 things that put a thumb on the scale. First this, and then giving these missing witness instructions, which is another significant point of prejudice to the defendant. But even if the prosecutor had made that...
The Commonwealth argues that after the missing witness instructions were given to the jury that your client didn't object, and so that for that piece of it, it's a substantial risk. What do you say to that?
What I would say to that is that the defense counsel vigorously objected when he was accused of arguing a missing witness inference. He objected to the prosecutor being permitted to burden shift both prior to when the court called them to sidebar and right after the prosecutor did that. The judge made her feelings in this known, and I would submit that that was sufficient to preserve the objection. But beyond that, even under a substantial risk standard or a mixed standard, you know, the burden shifting being preserved, even if this court finds that the objection to the missing witness instructions was not preserved, this created a substantial risk of a miscarriage of justice. You have a situation where a criminal defendant is, the Commonwealth is permitted to argue, and then the court instructs the jury that they may infer that they may make an inference against a criminal defendant based on his failure to call his own accusers to testify in his behalf. In Cobb, the SJC dealt with an almost identical situation, which was an argument by defense counsel that some witnesses had not testified, an argument by the prosecutor that the witnesses were equally available, and an instruction from the court that was a general missing witness instruction, but that contained some specific language to the defendant, which is what we have here. Some specific language, but a missing witness instruction that goes to both. And the court found that there was a substantial risk of a miscarriage of justice there. We have other cases, Broomhead and Ghiberti, that also come to the same result under a substantial risk standard. So what I would say is that regardless of the standard, this merits reversal, but also that it was what the defense counsel did was sufficient to preserve the objection, given the obvious futility of making a further objection at the time of instruction, given that the judge had really made her views on the subject known. And I think the important thing here is, the thing I want to draw the court's attention to is how disproportionately these two so-called dueling witness instructions impact the defendant. What we are talking about is undermining the presumption of innocence, the burden of proof beyond a reasonable doubt. That's why even in cases where the inference may be fairly drawn, where there is a foundation, the courts so consistently caution against allowing such an inference or making that instruction against a criminal defendant because of the impact it can have on those fundamental bedrock principles of our Constitution. What the prosecutor and the court did here was tell the jury that if Mr. Lesage did not present his own accusers to testify in his favor, that could be held against him.
So if we agree with you on this issue, his remedy would be another trial, right?
If you agree with me on this issue alone, his remedy would be a new trial, correct. I would argue that the new trial would be as to assault and battery only, given the Commonwealth's position, given the presentation of evidence and sort of the successive prosecution issue and the Commonwealth's position there. But if this court reverses on this argument only, yes, the remedy would be a new trial.
What is your response to the following? Let's say hypothetically, the panel agrees that agrees with the Commonwealth, because of course we examine this on independently, that there was error. But here you have a case where the evidence is really fairly substantial. You have a police officer who testifies to actually seeing a portion of the criminal event. And of course, the 911 call is fairly significant as well, because both parties can be heard on the 911 call. What is your response to the fact that there is really a case here of overwhelming evidence?
Well, my response is twofold. The first is that certainly between trial 1 and trial 2, the Commonwealth's evidence was strengthened by that 911 call, which I've argued was erroneously admitted. It should not have been admitted given the lack of notice to the defense until the morning of trial.
Well, let's assume that is not a win. Again, hypothetically, assuming
Right.
that's not a winner, that goes in.
That was getting to my second point.
Your
which
point is well taken, and it's not lost on us. Yeah.
Certainly. Assuming the 911 call was not improperly admitted and that it is being considered, that is certainly stronger evidence. But remember, at the first trial, the jury was unable to agree. So the police testimony alone was not sufficient to convince that first jury that Mr. Lesage was guilty beyond a reasonable doubt. You have the addition of the 911, yes, and does that strengthen the Commonwealth's case? Of course it does. That's why it's prejudicial to admit it. But you also have the absence of those two critical witnesses. The complainant is not there to testify. The 911 caller is not there to testify. There's no showing of availability or unavailability for the 911 caller. There's no explanation offered for his absence either before the jury or on the record, just with without the jury's presence. So you have these two witnesses who were the best witnesses who were there for the entire thing, one of whom called 911, one of whom was the complainant. Neither one of them is there. You have Mr. LESSAGE testifying in his own defense to an alternate version. This is still a credibility contest here, and the credibility of the Commonwealth's witnesses could be substantially in doubt given the failure or given the absence of the complainant and the absence of, and I would say Commonwealth's failure to call the 911 caller. So although the case is stronger.
One thing that confused me about the defendant's version was that it seemed like he was saying he was in the bedroom when the police arrived, and so like that they really didn't see him over the alleged victim hitting her. Was it that different? Did I understand that correctly?
Correct. I think that was the defendant's testimony. He was testifying, of course, through an interpreter. That's in the record. But that is how the testimony was interpreted and is in there. But critically, at the first trial, the jury was unable to agree. So whatever anybody might think about the relative.
Was that because they didn't have enough evidence she was pregnant?
I don't know why the jury was unable to agree at the first trial. I think the medical records do state that she was pregnant. They don't, that record is silent as to his knowledge of her pregnancy, so it could have been that. But it also could have been, again, you have police testifying to, as defense counsel said, a small snippet of what occurred, and you have the absence of the complainant and of the 911 caller at that first trial. So there were, we know the jury was unable to agree, and I would say
I can't remember. Was there? I'm sorry, I haven't seen this in the transcript yet. A lesser included instruction at the first trial on simple assault and battery?
There was not, no.
Okay.
There was none requested, and there was none. So we don't know what the jury, what I would say to your questions is we don't know what the jury decided at the first trial, only that they were unable to agree. And what I'll say, though, is that the burden shifting here was not the only impropriety in the Commonwealth's closing. We also have this argument of facts not in evidence, again, when we're talking about what the evidence showed.
So are you asking us, this is a relatively straightforward trial, but sometimes trials can be quite long. But here it seems undisputed the medical records did not show injury to her abdomen or her back. And yet the prosecutor argued that they did show that, right?
Correct.
So are you asking us to establish a rule that if it's just 100% clear that the prosecution misstated the evidence, that the judge should either let the prosecution say, I misstated the evidence, or the judge should say, the prosecution said X, that this is in the medical records, and the judge should say, it is not in the medical records?
No, I'm not asking for that rule. In this case, what I would argue is it wasn't clear, and there are sort of three reasons why this was a problem in the facts of this specific case. I'm not asking for any kind of global rule here other than to follow the law as it already is. The first thing is that the ADA's statement was the first time that the jury heard or saw this evidence. The medical records came in at the end of the Commonwealth's case, but they were not given to the jury until after closings. So there had been no testimony and no evidence that the jury could compare the prosecutor's statement to. The second is that the medical records...
But that was within a couple of hours, though. I mean, it wasn't a long time between the two, was there?
No, it was,
Okay.
no. The jury got them...
And they each got their own copies, as I recall.
I'm sorry for talking over.
That's all right. No, I was talking over. As I recall, they each received their own copy, right?
They did.
Okay.
But they received them when the case went back, which was the next day. So there was an overnight between the two. The closings happened on the 18th, and the jury got the instruction and the records on the 19th. But critically, what I would say here is looking at those records, they are filled with acronyms and abbreviations and jargon. And so what you have here is not readily, there's no ready falsifiability of what the Commonwealth said. The jurors could have looked at those records and assumed that one of those jargony phrases, for lack of a better way to put it, supported the Commonwealth's argument.
So what are you asking, what do you think should have happened here that's different than
What I think is that the court should have given a curative when it was requested by defense counsel. This was a preserved error. The Commonwealth had conceded that it was error, and that the court should have given a curative that this was not that there was no evidence of injuries to her back or stomach in the medical records. Because the medical records were not clear, and because the prosecutor really relied on this as a cornerstone of his closing. This was not some one-off comment. He used it to undermine the defendant's testimony, and he used it to bolster the police officer's testimony, saying that these injuries corroborated and were paired with the police officer's testimony, and that they were inconsistent with the defendant's testimony and made his testimony make no sense.
So what do you make of the fact that the judge seems to have, the judge said they heard something about injury to the back, but that was probably the police officer's testimony and wasn't focused on the medical records. But it seems like the judge misunderstood the medical records too.
I think the judge said, my recollection of the transcripts is that the judge said that there was a reference to no tenderness to the back or abdomen in the medical records, which is true, which is the opposite of what the prosecutor said, that was the reference in the medical records. So I believe that that's what the...
Well, he or she, I can't remember, on page 158 of the third transcript said, I did hear back. She said, I didn't hear stomach, I did hear back. But of course, that's testimony, not the medical records.
Correct, and I actually believe, I read that to be her referring to to what she heard in the prosecutor's closing, that she heard him say back,
Okay.
not stomach. But
And also, the next page, transcript 159, the court says, there is no tenderness on examination on exam of back and abdomen. The judge clearly, as you quoted correctly, understood at that moment that this was misrepresentation and
Absolutely.
and refused to give a curative specific instruction.
absolutely, and this is a preserved error. I see that my
Your time is up.
Time is
and
up.
I'm going to check with the panel to see if there's any additional comments or rather questions. And seeing none, thank you very much for your argument.
Thank you. And I'd ask you to reverse Mr. Lessage's convictions. Thank you.
Good morning, Your Honors. Timothy Ferreter, Assistant District Attorney from Middlesex on behalf of the Commonwealth. And I just want to start quickly with the double jeopardy claim and just correct an error I made in my brief. If you look at page 127 of the 418 transcript, you'll see that the court only directed out on the assault and battery with a pregnant person as far as it says pregnant person and not the full claim, and that's also reflected on the docket on RA 10. And then the parties agreed to go forward with one verdict slip being AB household family AB or not guilty. And therefore, I think the assault and battery conviction can still survive this case as either on count 1 or count 2 because there was sufficient evidence of assault and battery at both trials.
Can I jump all the way to the end for a second?
Absolutely.
The Commonwealth closing argument. The prosecutor's improper argument, it is defense counsel's job to try to distract you, to insert doubt into your mind. 418 at 154. I note that while you did concede error on a lot of things, you didn't mention this point at all. What's your position on that argument?
Sure. So I think that argument's close to the line, but I think when you look at the cases that the defendant cites to, such as Weaver, that case where they talk about the defendant's role, the problem the SJC had in that case was the Commonwealth's argument that the defense counsel, his role is not to seek the truth. I don't think distract is a particularly problematic argument. It is, in fact, the job of the defense counsel to try to sow reasonable doubt into the mind of the jury. So I didn't find that to be a particularly troublesome argument, certainly as compared to the other part of the argument.
Well, assuming we do find that troubling, what would the consequence be?
I don't think there's any objection to the argument about that it's the job
There wasn't.
of the defense attorney to distract you or try to create reasonable doubt. So I think, or to try to sow doubt in the mind of the juror. So that would be reviewed for substantial risk. And my argument would be the same as the other part of the closing argument where there was really overwhelming evidence in this case of the defendant's guilt. And I would point out that this case needs to be reviewed as it was tried at this trial and not the first trial, which I think was, because of the 911 call, was a vastly different trial. You don't have a 911.
Okay, so let's talk about, so overwhelming, you said overwhelming, and trial one is different evidence. So I'm guessing that when you say it's overwhelming, it's because of the 911 tape. So it felt to me like there was at least a plausible argument that this was trial by ambush on the 911 tape. I dug deep into the record. I could not figure out whether or not this 911 call was produced to the defense. Obviously, you're limited to the record. Can you clarify for us whether the record establishes that this 911 call was produced to the defense?
I mean, so the way I read the transcript, the defense counsel's objection was that he did not receive notice of the dispatcher. I don't see anywhere in the record where he says, I didn't receive the 911 call. Yeah,
but let's focus on the prosecutor. The prosecutor says, I can't quote it, but to something to the effect of, I didn't have this, and it read to me as though the prosecutor was delayed in obtaining the recording from the police department.
He said he didn't have access to it, and I don't have any idea what he means by that. And I think you have to look at what the defense attorney says. I can't imagine any defense attorney who didn't receive a 911 call before the day of trial not stating that directly and that being his clear objection.
Well, I can imagine it. So first of all, a defense lawyer may not want evidence that's bad, but it was clear here that from the incident report that there was a 911 call.
Right.
And so the question, I think your opponent makes this point, it's a fair reading that he was aware that there was a 911 call from the very earliest moments of the investigation. The question is what the contents of that 911 call were, and that requires the police department to record it and then turn it over to the DA's office.
Right.
And so that's what I'm wondering, and it seemed impenetrable to me, but it also seemed consistent with the prosecutor saying, I didn't have access to this, that he didn't actually have the didn't have the recording until sometime shortly before trial, the second trial.
So I would point out that the whether to discovery sanctions are abuse of discretion standard, and I don't think there's anything on the record that can show in this case that the 911 call was not turned over, and therefore the judge's decision was incorrect. The defense attorney was asked twice, were you aware of the 911 call? He says, I was. He's asked again on page 5, well, you had notice of the 911 call, correct? He says, yes. And he never says, but I didn't have, no one ever turned it over to me. His objection is clearly that he did not have notice of the dispatcher, and that's why he requested a voir dire of the dispatcher. He never says on the record his objection is that I didn't have the call.
If the district attorney didn't have access to the 911 call until between the two trials, you think that somehow the defense attorney got it without the ADA knowing?
I don't know if a previous ADA turned it over and it was in their computer file and not transferred. I really don't know what that means. So I think
Was it the same defense counsel in both trials?
Correct.
And it was not the same ADA?
No, it was the same ADA.
Same ADA as well?
Correct.
Okay.
But I don't know if the case was transferred to him between arraignment and discovery and trial, so I don't know what he means by I didn't have access to it. But I think it's pretty clear that the defense counsel never says that I did not have the 911 call.
Okay, so assuming we are focused, assuming it is an overwhelming case, and assuming that the prosecutor misstated the record on what I would say is fairly characterized as an emotional point, a pregnant woman being punched in the stomach, and the defense counsel objects, brings the judge's attention to it, and the judge refuses to correct that. You're saying that is harmless error?
Correct, Your Honor. I think we certainly be in a better position if there was a curative instruction, but if you look at the record, the medical records on page RA 33, it directly says there's no tenderness on exam of back and abdomen. The prosecution,
that's helpful to you?
I think it's helpful in the fact that the evidence was in direct contradiction. Each juror was given a copy of the medical records and would have seen that the prosecutor's argument was a misstatement. I think this is similar to Taylor, the case I point out in my brief, where the things relied on by the SJC in that case was that there was a short trial. The testimony was in direct conflict, and so the jurors wouldn't have been aware of the factual dispute. The judge's instruction that closing arguments are not evidence.
Can we conclude that where the evidence that was in direct contradiction was in the medical record? And so, yes, each juror got the medical record, but how do we know that they read them, and how do we know that they understood?
I mean, we can't know for sure, but I think the medical records are short. There are only a few exhibits, and they were each given one, and I have to assume that they reviewed the evidence in this case.
Well, let's back up for a minute, though. So you agree that what the prosecutor said is in fact not in the medical records?
100%.
Shouldn't the judge have then, and the judge was told that, shouldn't the judge have said it's not in the medical records? Like, should we really be leaving this to chance?
I mean, I don't think we're leaving. It certainly would have been better when she recognized that there was not an evidence to give a direct curative instruction. She gave the general instruction that the jury's memory controls and that closing arguments are not evidence.
There's no memory here. It was a documentary record.
Correct, and I think the documentary record directly contradicted what they said, and each juror was given a copy of it. And I know there are acronyms in the medical records, but there is a plain English statement saying that there was no tenderness of the back or abdomen. So I think the jury...
Yeah, I know, but how long did they deliberate? Wasn't it like 45 minutes?
I know they came back the same day after the
We have the testimony, I mean, I guess it's a question to me whether, we have this emotional appeal that the defendant punched a pregnant woman in the stomach, and that, we don't have any evidence of that, right?
Correct.
No testimony and no record evidence.
No, the testimony that the police saw him punch her in the back. Correct.
Lightly, whatever that means. I don't know why that qualification was in there. He punched her in the back. But no, there was no evidence of any kind that he punched her in a pregnant woman, and you don't think that's a real emotional gripper?
No, I've conceded that this argument should not have been made, and I understand your point about this being particularly emotional in an AB pregnant woman case. But I would just, go back to the evidence here, and I think it was overwhelming where you don't just have the 911 call is not a report of a past crime. It is a live play-by-play of what the victim's son is seeing. He says on the 911 call, "Oh, bro, he just hit my mom in the face."
Does the jury know that it's her son?
I think he says on the 911 call, "It's my mother." So yes.
So unfortunately, it's not the only error, this misstatement of the fact on an emotional point. You've also conceded that the missing witness argument was error and burden shifting. So your opponent makes a good argument in her reply brief at 25 that we have to consider that all of these errors together, which I think is absolutely appropriate. So you've struggled mightily to overcome the factual error on an emotional point, but what about the totality of the prosecutor's errors in closing?
So in terms of the missing witness instruction, I really think that inured to the benefit of the defendant. He focused his closing argument on the fact that the victim and the 911 caller did not come to testify. He was clearly he didn't directly tell the jury to find that the victim and 911 caller would have testified to his benefit, but he was clearly trying to get the jury to imply that to the jury. And when you compare that...
He wasn't simply trying to argue the bedrock principle that they need to prove their case, and they didn't produce the witnesses that are central to that case, strike that second part, that they didn't prove their case.
So I think Salatino, it leaves a lot of gray areas to exactly what a defense attorney can argue when a witness does not appear. And I think his argument here, towed the line, but it was clearly trying to imply that it was unfair that he was not able to question these witnesses. He says in his closing, wouldn't this person, the 911 call, which is central evidence to the case, don't you think you'd want to hear from that person? Don't you think I should get an opportunity to question that person? And then when he's talking about the victim, she didn't see a small snippet like Officer Calnan did. She was presumably the best witness. She was there for the entire events, but she didn't testify today, and the Commonwealth has the burden. I think he was trying to create an implication of the jury that if they had testified, it would not have come out the way the Commonwealth alleged. I'd point out the cases where were reversed based on the missing witness instruction being given in favor of the Commonwealth, such as Cobb and Broomhead, are cases where it was only given for the defendant not calling a witness, and the Commonwealth strenuously argued that in their closing. Here, there's one passing argument by the prosecutor that the defendant also could have called the witnesses, and it was not the inference that the witnesses would have testified favorably for the Commonwealth was not made by the prosecutor. So I do think that separates these two cases, those cases from this case. And I'd also point out that the instructions were not objected to. At the sidebar, the defense attorney certainly argued with the judge's characterization of his closing, but he did not object to any closing argument, to any jury instructions. So that's on page 1.
So you're saying it wasn't enough for him to say, I didn't do that, which the implication of which is the instruction is not warranted, that that's not enough to preserve the issue?
I mean, I think the judge essentially said that the inference wasn't warranted, and so I don't think there would have been any reason to think that the judge would have given an instruction. I think you have to put the judge on notice that when you disagree with an instruction, you have to object to it. There's no discussion of the missing witness instruction at that sidebar following the defendant's closing, so I don't know how the judge would have been on notice.
Do you agree that with your opponent's point that, or argument, that the dueling missing witness instructions are disproportionately impactful, where the Commonwealth bears the burden, the defendant has a Fifth Amendment privilege not to testify?
I think in theory, I agree with that, but not in this case because of the closing arguments in this case. It was clearly the tactic of the defense attorney to push the fact that these two witnesses did not appear and testify, and that it was unfair to him that he did not get to question these witnesses, and that the jury should hold that against the Commonwealth. So I agree with that in theory, but when you look at it, how it was argued in this case, I think there was a tactical reason not to object to that instruction. I think the defendant wanted that instruction because he wanted the jury to make that inference in the defendant's favor.
So just a couple of quick questions, I hope. Is the defendant correct that he was only informed the day of the second trial that the Commonwealth would be advancing the assault and battery on a family member charge?
I don't know what happened between the two trials, so I don't have an answer to that.
Okay, and well, the other question then is, when was the defendant first informed about the authentication witness? Because he says it wasn't, the person was not, this is, I assume, the 911 person, was not on the Commonwealth's witness list for the first trial, and there was no pretrial conference report
Correct.
filed.
So he was not informed of the dispatcher until the day of trial. That was his objection, and he requested a voir dire, which was held. And if there are no further questions, I'll rest my brief and ask you to affirm for assault.
Thank you both very much.
Thank you.
Both of you, your arguments are very helpful. We appreciate it. All right. The next case is Commonwealth versus a juvenile, number 2023-1209. And I remind everybody in the courtroom that this party's names have been impounded. Good morning.
Good morning. Michelle Mangiano on behalf of the juvenile. May it please the court. I'd like to address 3 issues today, time permitting. The nature and impact of Detective Ovales's improper testimony, the ineffective assistance of counsel claim, and the sentencing issue, which is more complicated than it may appear in the briefs.
No, it appears complicated.
Well, maybe a discussion would be of assistance then. With respect to Detective Ovales's testimony, there's no serious dispute that he testified improperly on multiple occasions. The Commonwealth acknowledges that when he testified to having had prior encounters with the juvenile, and when he testified to having familiarity with the 2 brothers in the iPhone photo, that these could impermissibly imply prior bad acts. And while there's some suggestion that perhaps These were not statements of identification in violation of the judge's ruling with respect to the identification. Certainly, they violated the judge's explicit ruling with respect to the juvenile's bad acts motion. And she specifically acknowledged that the motion called for an order precluding the Commonwealth's witnesses from insinuating knowledge of prior criminal conduct.
I'm going to interrupt you and just ask you, there was a significant limiting instruction at this point, right? I think the record does indicate, and the Commonwealth has conceded, that this went beyond what was permissible in terms of testimony. What do you say about the instruction that was given to the jury to disregard it?
So the instruction to disregard came with respect to the two brothers' comment, and this came after the previous comment where Ovalle said that he immediately recognized the juvenile, even though the juvenile was wearing a balaclava on his face from prior encounters. So the limiting instruction did nothing with respect to the similar prior error. And really, I'm asking this court to look at the pattern of conduct by Detective Ovalle. It had a cumulative prejudicial impact. So yes, there was an instruction given with respect to one little piece, but there were other others, the one I just referenced, and there were the augmented photographs that the Commonwealth concedes should not have been admitted, and various other errors discussed in the brief. And the effect of all of this together was not mitigated by that one limiting instruction.
So one thing I'm confused about is you're saying he shouldn't have been able to look at the high school video and say, look, he's got, this person has white symbols on both thighs. He's not supposed to say that? Right?
I am saying that, and the SJ...
But could the prosecutor argue in closing he's
Yes.
got white symbols on the thighs, but during the actual testimony, nobody should point out the white symbols?
That's correct. So, and there was, and actually in the motion in limine transcript, which is extensive, there was, defense counsel made it clear, I'm not objecting to argument, that's argument. It's fair argument from the evidence that's properly before the jury. But the case law is clear that the witnesses are not to be describing the clothing or, more importantly, comparing the clothing of the person that they submit is the defendant at bar and the person that is the perpetrator on the video. This is impermissible. It's impermissible under Greer, and it's impermissible under the Gomez case that recently came out. It was not a big deal, but on factors that...
You're saying it was not a big deal in the Gomez case because the case was not reversed on that point.
Correct.
Okay.
But what the court said there is that, importantly, and I've lost my note on this, but importantly, the witnesses did not describe the clothing, and they did not make a match. They didn't try to compare. And in fact, the SJC said that the judge made sure before the compilation video was put in that no such testimony would be forthcoming. Similarly, in Greer, there was a question of a suspect on images wearing a C on the sweatshirt, and the witness did not describe this feature or, more importantly, try to connect that feature to clothing of the accused. And all of these errors actually did happen here, and they combined to convey an impression that Detective Ovalle had superior knowledge, even knowledge extending beyond the evidence that was presented to the jury of who the players were. And these were, in fact, the very questions that the jury had to answer. Is that the juvenile on the Central Catholic videos? We know that there's someone who looks an awful lot like him, and we have nothing else connecting him to those videos beyond the resemblance. So is that him? Does that clothing match the clothing of the perpetrator? Does it match it?
I'm trying to on a common sense, intuitive level, understand the problem here, and specifically the two insignia on both thighs. And so I've reviewed very carefully the still shots, and it seems that the person, no, there seems to be a look-alike, so this throws a wrench in everything, but put this look-alike to the side. The guy who seems to look most like the defendant has insignia clearly on both thighs. The surveillance video shooter, it seems, it's tiny, but seems to have insignia on both thighs. The Ramos, I guess, I'm not sure, another possible suspect who's in the camera, the school camera, has insignia only on one thigh. And so I think Ovales broadly is pointing that out. How is that unfair?
Okay, before I answer the question, how is it unfair, I just want to point out that there is no evidence in the record as to who the other potential, the white sneakered individual on the central. There's no evidence as to who that is.
Right.
It's unfair because that's what the jury's job is to do. There were I could point to, and I did in my brief, other similarities and differences between the second white sneaker. The sweatshirt, the top is different. And there were 3.5 hours between the Central Catholic events depicted and the events depicted at the shooting. But anybody could have...
Fair point, but I mean, at least on the white insignia on the thighs, it was factually accurate as far as it went that there were these similarities. In other words, that was not a factually erroneous comparison, right?
Correct.
Okay.
I mean, what's visible is what's visible, but it's still, the point is that you have a lead detective who has looked at these videos over and over again, as emphasized by the Commonwealth in closing, and is essentially conveying, here's why I am of the opinion that the accused is guilty. And, here's my thinking, and I am an expert in all things law enforcement and investigation, and so this is the case, Justice Henry, where the jury deliberated for 45 minutes, and it was over lunch. They asked for lunch while they were eating. It was a very fast turnaround, despite the fact that there were some actual issues to be determined, and I urge the court to find that that is because the jury was spoon-fed the conclusion here.
Do you think that, I'm taking from your argument that your emphasis on the video and the alleged opinion testimony, we'll call it that for now, was the critical point. But there was other evidence that tied your client into the shooting, primarily the firearm.
The firearm that he possessed, there was evidence that he possessed a week after. And really, that is I would submit, the strongest evidence that the Commonwealth has. And when the Commonwealth is laying out its best case, you'll notice in the Commonwealth's brief, the Commonwealth says that the case was circumstantial but convincing. It doesn't claim that it's overwhelming. And it talks about what the jury could infer and could find and could conclude. And that the evidence permitted a finding of guilt is not the standard here. At a minimum, the Commonwealth needs to satisfy the substantial risk of miscarriage of justice standard, which we submit it's actually prejudicial error as briefed. But if it's substantial risk of a miscarriage of justice error, then still under ALPHIS, I mean, the evidence should be strong and one-sided with no genuine issue of guilt or innocence. And I think there were some genuine issues here.
And now on the phone that seems to have, so just briefly on the timeline, there's some time between the shooting and the arrest, right? It's like a week?
It's 1 week,
Okay.
yes.
And we have these photographs of arguably the juvenile holding a firearm on the cell phone, but nobody gave any dates for any of those photographs?
That's correct. It's undated. It could have been from the 22nd, the date of the arrest. The Commonwealth points out that the clothing is different in the booking photos from the 22nd and the iPhone photo, so the Commonwealth suggests that
It was before
that
the
precludes my
22nd.
argument that it could have been the same day, but it was a white T-shirt and then a sweatshirt, so I don't think it's inconsistent. We have no idea when.
And the police didn't find the item, the sweatpants with the two symbols on the thighs?
They did not, nor the sweatshirt, nor any other ballistics firearm evidence in the search of the juvenile's room.
And the Commonwealth was contending the red underwear is visible on one of these photos, is that right?
It's sort of implicit. The record is not, that was not clearly conveyed to the jury. I think the best happened in the Commonwealth's closing argument, that there was red underwear visible. But the Commonwealth also acknowledges that, and as the judge observed in making the rulings, that all of these clothing items were ubiquitous in the community.
Could we spend some time quickly on the defense lawyer's opening statement promise?
Yes. So I would like to touch that briefly. I'm concerned about time for sentencing. I think that what I would like to say today is that the Commonwealth concedes that the defense that was promised in opening was a non-viable defense, and then urges that basically that means it was non-prejudicial. Because in order for an error of counsel to be prejudicial, it has to have deprived the accused of a substantial ground of defense. Where this was not a viable defense, ipso facto, juvenile was not deprived of a defense. And I would just urge the court that that really doesn't make a lot of sense. I mean, where the courts have repeatedly recognized the inherent prejudice of an unfulfilled opening promise, it really doesn't make a lot of sense to focus on whether, with promising a non-viable defense, to look at the prejudice analysis the way that the Commonwealth has urged, and instead to look at, as in Duran and its progeny, and a federal case of Uber v. Guarino, which got deep into this issue, though really to look at the bottom line of the Strickland analysis. And Uber is 293 F. 3rd 19. It's a 2002 case out of the First Circuit. The question is whether there's a strong possibility that it affected the outcome. And so you look at the indicators of how this would have impacted.
We're pretty familiar with what we have to look at, and I want you, if you don't mind, I don't
Yes.
appreciate interrupting you, but if you want to get to your sentencing argument, I think you better
Yes.
move to it now.
Thank you. This is all turning on a disagreement as to one sentence in the statute, and I have the statutory provision printed out, extra copies, if anybody needs it right in front of them. The statute, subsection A says, the potential penalties are either 2.5 years minimum or 18 months minimum in jail, 2.5 years.
And which was imposed, 18 months.
18 months was imposed here, and then the sentence was split. Then the second sentence.
So why is it that a split sentence is not permissible?
Because the second sentence says, I'm going to read it with emphasis and then go back. The sentence imposed on such person shall not be reduced to less than 18 months, nor suspended.
And it was not?
Nor suspended.
The 18 months was not suspended. Go ahead.
That's right.
Yeah, okay.
But a split sentence is a suspended sentence. Nor shall any person convicted under this subsection be eligible for probation, parole, work release, etc., good conduct until he shall have served 18 months. Now, the Commonwealth reading...
That part is, of course, also happened. The 18 months will be served.
So I disagree on this because I think that the reading that you're suggesting and the reading that the Commonwealth suggesting...
I'm just trying to go through with you line by line, so I'm not suggesting anything to you yet.
Okay. If there were a comma after good conduct, then the clause, the separated clause that followed, which is until he shall have served 18 months, would relate back to all of the antecedent clauses. But there is no such comma. The comma comes before nor shall such person yada, yada, yada until 18 months has passed. That means that it shan't be reduced to less than 18 months, nor suspended, nor will the person be eligible for these ameliorations until 18 months are gone. Not suspension. That precedes the comma. And the way that I have read it is the way that the SJC read it in Rodriguez as well as Lightfoot. The fact that this contains a reference, if I may just continue.
Yes, just finish your
Thank
thought,
you.
yes.
The fact that this contains a reference to 18 months, I believe the Commonwealth is interpreting to mean that it relates to the House of Correction sentence, because the House of Correction sentence also has an 18-month minimum. However, this same exact construction appears in other, so for example, in 10M, which was which was interpreted by Rodriguez, it was 2.5 years was the mandatory minimum, and then it said, shall not be reduced to less than 1 year, nor suspended. There were two different statutory minima. This court, this is the last thing I'll say, in a case called Haley, 23 Mass App Court 10, interpreted the vehicular homicide statute, which had a similar construction, but did not contain the language, nor shall blah-de-de-blah after. The court actually suggested the construction that is adopted in 10A and 10M in that Haley decision, which was dated 1986. So the Haley court reads this as there's a minimum, and then there's this other business about parole, furlough, these ameliorations, and there is a separate mandatory minimum that relates to those. So that's the interpretation of the statute that we're urging. Thank you very much.
Thank you very much.
Good morning. May it please the court. Jennifer Cohen for the Commonwealth, and I have the trial prosecutor with me at counsel's table, ADA Alyssa Fournier. Of course, in the Commonwealth's brief, we did concede that there were certain portions of Ovalis' testimony that would have been better left unsaid, specifically his familiarity testimony. I do believe that the testimony relating to familiarity with the individuals in the photograph, there was a very strong curative instruction there, and that reference was struck from the record. So I would say that there's no error there where the jury were instructed not to consider.
She says there was no curative instruction related to some of the other errors. Is she right about that?
That is correct, Your Honor.
And, I mean, she basically sums it up by saying the lead detective in this case offered his opinion that these two individuals were in the high school video and the video near the shooting were the same. Did he essentially do that?
I don't believe that he ever, he never identified anyone in the high school video or in the shooting video. He did compare the clothing of the individuals in both of those videos, but the identification as the juvenile in either video was entirely left to the jury.
Did he say the clothing in the one video was the same, or?
He said that they were consistent. He did say that, and he did point out to the jury, specifically what he was looking at as comparing. I think the strongest language that he did use was consistent. But I would also say at other points of his testimony, he essentially agreed that none of these items were unique, that he owned a balaclava, that he owned black sweatpants, some had emblems, and he agreed that white Nikes were not uncommon. I would also note that kind of on a spectrum of Wordsworth being maybe one of the worst cases of comparison between a defendant and someone in a video, and Greer and the Gomez case on the other side, that this case falls somewhere closer to Greer and Gomez. I agree that in this case there was more testimony regarding the particular items and why they were of import to the detective. However, I think there's a big factual difference here, and is that when the clothing was compared, again, no one in the video had been identified by the detective. In Wordsworth, there had been a shooting, the defendant was arrested near the scene, and officers directly compared the clothing worn by the defendant when he was arrested to the clothing of a suspect on a video. Similarly, that was the case in Greer. There was much less testimony about the actual clothing. However, you had a defendant who'd been arrested near the scene of an incident and surveillance video. So I would argue that any comparison there would have been much more damaging than it was in this case.
Fair point. Your opponent makes what seems like a significant point that Detective Ovales had been instructed how to proceed, and there were at least 2 examples in the testimony where he simply ignores the instruction, keeps charging ahead, and then says, I'm sorry, I get confused between sustained and overruled. And he's a seasoned detective. And your opponent makes the point that that doesn't ring true. And I think that he had done something like this in a trial recently before this. Does any of that factor into the materiality analysis?
I won't argue with my sister on what occurred in this trial. It's clear from what the
Meaning
judge...
you concede that that's accurate?
I concede that it was clear that the judge was not happy with the detective, and it was clear that she viewed him kind of as going rogue in his testimony. He clearly, from her admonishment, I think, was not listening to the trial prosecutor's instruction that he was not to say certain things. I think that was very clear. But I would argue that that doesn't necessarily go to the outcome of this case. I think when we're looking at, the standard of review on each particular issue, although I agree that he certainly said things that he shouldn't, I don't think that that necessarily goes to whether or not there's prejudice or a substantial risk of a miscarriage of justice.
So if we just keep affirming, then how do we stop this, I'll use your phrase, rogue behavior?
Well, Your Honor, I would say that the judge, in considering how to ameliorate this issue, had the option of declaring a mistrial. She considered all of her options in this case.
But he walks away thinking, I got away with it, I'm doing it again, right?
Well, I mean, I would say in the context he was told not to do this, and that was not appropriate. And I think it would have been appropriate for the judge, in considering all of her options, to have decided on, anything from a mistrial to the instruction that she decided to give. Those all were options that were available to her, and considering, the trial in its totality and how she saw evidence coming in, she felt that the instruction was the best way to handle this.
So obviously, I think we have to consider in analyzing this rogue behavior and its materiality, the strength of the case. And you've conceded that it's a circumstantial case. And there's a surface appeal that the juvenile is found, there's photographs of what seems to be the juvenile with a gun a week later. We don't know when those photos are taken. But there's lots of stuff we don't know here as well. And it seems like a deeply troubling case. And then most troubling of all to me is this photograph at RA 69, where there's another fellow behind him who, to my eye, looks shockingly like him. He's characterized as a look-alike. Nobody ever says the word twin. I can't tell. But that to me is deeply troubling. I've been thinking about that photograph for the last 3 days. How can you say, and in light of the actual surveillance photos that are teeny and far away, and 3.5 hours after the surveillance photo, how can you say that this couldn't have made a difference?
Well, I would say, Your Honor, that the identification was left to the jury. And I understand Your Honor's point here with the photograph. The individuals do look very similar. I think that the jury could infer that this was a selfie photograph taken, and that the phone that the photograph was taken on could have been the juvenile's, based on the fact that there was a birth certificate and social security card image on that phone. So I think, I agree, there is a similar looking individual, but I think you could infer that the person taking the phone and the person holding the firearm was the juvenile, if they identified him as the juvenile, because again, that was left entirely to the jury. So I think, I understand Your Honor's point. I do think that there's enough circumstantial evidence here to link the juvenile to the crime, given the totality of the evidence. But I do agree, it's circumstantial.
And the record was that this neighbor found this phone and guessed the password?
I believe so. He was able to get into the phone that he found in his yard. Okay. Perhaps it wasn't
All right, and then looking at the images, which
It
I...
goes 0000 or something like that, yeah.
Okay. Looking at the images on the blue brief, page 13, it does seem like one person with white sneakers has a lot of hair and a beard, and the other person does not have a lot of hair and does not have a beard, right?
Yes, correct.
Clothing-wise, they look similar, but...
Yes, but I would concede that the shooters in the video are all wearing balaclavas. So although that is relevant for identifying the juvenile as potentially one of the people in the high school video, they're...
And my recollection is that the fellow with a lot of hair in one of the school surveillance videos, there's another surveillance video, that fellow, it seems, or puts something over his head, and suddenly the big hair is not visible anymore.
Correct.
Right.
Your Honor.
Right.
I will turn to the ineffective assistance claim if there's no further questions on this issue.
Quickly, because then you want to get to the issue of sentencing.
I did, as a first point, of course, argue that the court shouldn't consider this issue for the first time at the appellate level. I did argue that this was never, that third-party evidence where you're pointing to your joint venture was not a viable defense. However, third-party culprit generally was a viable defense. And even if it was unreasonable for defense counsel to specifically point to joint ventures in his opening, it's clear that his theory of the case was that the juvenile was not one of these three shooters. So his defense was still that there was a third-party culprit. So I would argue that the defendant, I'm sorry, the juvenile was not deprived of an otherwise available substantial defense.
What about her argument that that's really not the right standard when the issue is that there was a completely baseless claim made in opening that then was a broken promise?
So I would say, at the core of the defense was third-party culprit. He was not entitled to point to the joint venturers, but he was entitled to raise third-party culprit. And in fact, I think that was his best defense because he wasn't disagreeing that the shooting ever occurred. So I think, third-party culprit made sense, and that is what he stuck with until the end at his closing.
Yeah, but I don't want to belabor this. I want to give you time, but very quickly, his promise wasn't just third party. It was, we're going to learn that they had gun convictions, which was clearly wrong. But the point is, his promise was much more specific than that. And so his broken promise was much more specific, and I think under Uber v. Guarino, much more prejudicial. So how do you address that quickly?
I would just say, Your Honor, the jury are instructed that the openings are not evidence. I understand, he's rung the bell. He did stick with the third-party culprit evidence generally. I understand the court's point, but I would just argue where the core of the defense remained the same, although that particular evidence didn't come in, the core of the defense was the same.
Thank you.
And turning finally to the sentencing issue, I would just state that the 10A statute is worded differently from 10M, which is discussed in Rodriguez. In 10M, a person convicted can only be subject to state prison time. In 10A, there's obviously a provision for state prison time, and then there's also a provision for jail or House of Corrections time. And I argue that the 18 months is a mandatory minimum for jail or House of Correction time, and that is what the defendant received as part of his split sentence.
Okay. Further questions?
Do you, whenever cases come down to grammar and commas, do you think she's right that it's significant there was no comma in 10A?
I don't think so, Your Honor, because I think that, I don't think so because of the two, I think it's clear that the suspension can't be less than 18 months. In all respects, the 18 months is a mandatory minimum for the jail or House of Correction time. So I think comma or no, I don't think that factors in.
And that is the portion of the statute, the portion of the sentence that cannot be suspended or changed or
Correct.
or
It
anything
must
like
be
that.
18 months minimum.
Okay.
If there are no further questions, I will rest on my brief. Thank you.
Thank you both very much for your arguments. They were very helpful. A number of complicated issues in this case. We'll take the case under advisement. All right, the next criminal case we have is Commonwealth versus Stephen GREANY. And please tell me if I pronounced that correctly, 2024-0407. All right, Counselor.
Good morning. May it please the court, my name is Kevin Connolly. I'm representing the Commonwealth this morning on its appeal of the district court judge's allowance of the defendant's motion to suppress. Now, in order to articulate my argument, I'd like to briefly address the facts before actually getting in the motion judge made. A city supervisor told the chief of police that the defendant, a former police officer, now a facilities worker for the city, that he was making off with city property. He was taking it home. The police were able to corroborate that report by the named informant, by their independent efforts, corroborating it by a surveillance, and they saw the defendant doing just that.
Taking the dartboard inside, right?
I'm sorry?
Taking the dartboard inside to the
That's
home.
right. City property, taking home on his lunch hour. Now later, police, 3 officers, plain clothes, 2 unmarked cars, they approached the defendant. He's working outside a city library.
Right, then things are a little less clear because the prosecutor really could have gone into a bit more granular detail. So I can't tell that the defendant consented to searching his home before he got in the police car.
Well, my reading of the transcript is there is a discussion outside the Holland Green Library in which the police basically say, this is what we know. The police said that they were going to his house. And there was mention, they explained to him they could apply for a search warrant.
Well, the transcript is the transcript, and I think it's fair to say that the chief and 2 very experienced officers said to him, look, we're going to get a warrant or you're going to give us consent. Which is it? What are you going to do? It was, that's what everybody agrees happened, right?
Yes, that's a fair characterization.
Okay.
And the defendant, given Miranda at the time, said, I know my rights. In any event.
But he says, the defendant argues that the involvement of the chief of police, which the other 2 experienced officers say they had never, ever seen, created this inherently authoritative and intimidating environment. So what do you say to that?
Well, that's a very colorful claim, but it's really not really supported by the record evidence at all, which, by the way, the judge expressly credited.
Isn't that getting to your real problem here? And that is the judge expressly credits the testimony of the 2 officers, which, if you credited their testimony, would indicate potentially that there was consent. But she makes 0 findings on these issues and doesn't really say on what basis or what happened at the library or what happened in the car or what happened in the house before the safe was actually searched as well.
That is my argument.
So
yes.
did you ask for reconsideration for more findings of fact before you took your appeal?
We did not, Your Honor. We did not.
And would that perhaps have been a better route to take at that time?
Well,
Because now basically you're asking us, if anything, to remand it for findings.
I think it should be remanded actually, that's an alternative argument of mine. I think it should be reversed.
Can I ask a clarifying question? Voluntariness. I mean, she found that it was that the consent was involuntary.
She concluded that.
Right. Okay. And concluded. I guess you're anticipating my question. Is that a finding of fact or a finding of law? And if it's a finding of fact, I think the question is whether it's clear error.
See, I don't think it is a finding of fact.
Okay.
The handwritten endorsement here raises more questions than it answers, actually. If it were a finding of fact, I would suggest it's clear error. But instead, my argument is that it's a conclusion of law, and therefore, it's up for grabs on appeal, right? De novo review is what the court will engage in. In any event, the defendant is not even remotely arrested. He accompanies the two officers in an unmarked car, and en route, he signs the consent form after his rights are explained.
Right,
Now,
but the defendant relies on Bumper versus North Carolina to say basically that that he was really essentially given no choice, that they represented they had authority to enter the house because they could go get the search warrant. So why is that case different?
Bumper is a lot different. First of all, it was a 60-plus-year-old black woman in a house miles from anywhere with a bunch of children running around, and the police went up to her and they said, "I am the law. I have a search warrant," basically conveying, you get out of the way and let us search the house for your nephew's rifle. Later on, at the hearing, they said, no, we rely on consent. And what did the court say there? That all she did really was acquiesce to a claim of lawful authority. She was not a former police officer. The encounter did not occur in a remote place with 4 white guys in ties banging on the door. That case is miles different from this.
Can I circle back to the voluntariness as a question of fact? I'm reading from the defendant's brief at 18, and they in turn are quoting Commonwealth v. Gaynor, 443 Mass. 2005. Ultimately, voluntariness of consent, as well as the scope of any given consent, quote, is a question of fact to be determined by the motion judge from the totality of all the circumstances, close quote. So if voluntariness of the consent is a question of fact, and it's reviewed for clear error, well, first of all, am I right about that much? Is the defense right about that?
Well, an examination of the totality of the circumstances implies fact findings, and we don't have the benefit of those here.
Okay. Gotcha.
Now, he lets them in, when they get to the house, he lets them in the basement. He shows them the items he has, the city property that he has taken, various other things. And claims they were being discarded. He says, well, I'm going to sell them on eBay.
And he's saying nobody verified whether they were being discarded, but you're saying because the supervisor called the chief of police that refutes his position, is that right?
Yeah, this is my argument, right? It's described as city property, meaning title is in the city. The defendant is taking and carrying away the property of another, secreting it in his basement with intent permanently to deprive.
Well, if he got it out of a city dumpster, would that be okay?
Yeah, it probably would be.
All right, well, so if his boss said, put this in the city dumpster, and instead of doing that, he drove it home, would that be okay?
I'm sorry, I didn't hear your question, Judge.
If his supervisor said, put this dartboard in the city dumpster, and instead of doing that, he just drove it home.
That's the equivalent of saying we're discarding it. Yeah.
He'd be okay in that situation.
Yes, because title would not be in the city. This is a larceny, though. It's a larceny because the chief was informed that it was city property, not abandoned property, not discarded property. It was city property that the defendant was taking. And in any event, the atmosphere, which the judge credited, is calm, is cooperative, it's casual. There's a safe. Would you open the safe? Well, the defendant says there are pictures in the safe that I don't want you to see. The police then mention, again, the warrant option. And what does he do? This is not a question of ambiguity like in Ortiz, right? A statement that we have to somehow interpret it. We're not asking the court to interpret the statement. His action speaks louder than any words. He opens the safe himself. No ambiguity there.
I'm struggling. The consent has already been given. It's been given in writing.
Yes.
And the judge has found that that consent was involuntary. It happened before we got to the basement. So I'm struggling to understand analytically why anything that happens in the basement, including the giving of the code, matters at this point, if, in fact, we find that the judge did not err clearly in finding that the signing of the consent form was voluntary.
You're correct, Judge. In other words, if the police entry into the home was not the product of valid consent, everything falls.
Right.
But let me proceed. That is not actually obviously my argument.
Sure.
Inside the safe, the police find the Suboxone, alprazolam, and testosterone. Also in the basement, the police find, not in the safe, quantity of marijuana, scale, ammunition, cash.
And I don't see how the record's clear about when they found the marijuana and the scale.
Judge, it isn't clear, and it doesn't matter. The order in which these things were found is not particularly material.
I have another question. There was a second safe, I think, and in the second safe there was $6,400. Was he accused of stealing that? Is that material? That $6,400?
The money, the $6,400?
Yeah.
No, I suppose that not material to the investigation,
Okay.
right?
Right.
But it could be material to the possession with intent to distribute of the various controlled substances.
Well, I saw nothing in the record about how they got that open. In other words, is it how the police, was it already opened?
That I don't know, and it's not a matter of record.
Okay, thank you.
So the trial judge, the motion judge, expressly credited the uncontroverted, the undisputed testimony of these two witnesses, but she suppressed, concluding that consent was invalid, and she did not make any findings of fact. So my three arguments, briefly, are this. The trial judge, in her memorandum, in her handwritten endorsement, I should say, incorrectly regarded probable cause as a necessary predicate to consent. It isn't. And by the way, there was ample probable cause in this case. The police were not bamboozling Stephen GREANY when they told him that they could apply for a search warrant. And why do I say that? I mean, it's a common sense, fluid, non-technical concept, as the court knows. The facts and circumstances, as I've explained them, gave the police trustworthy information that there was a larceny afoot and that they would find evidence of the larceny, not just the larceny wreaths, but evidence of the larceny in the defendant's home. It seems to me hard to argue that that the police were lacking probable cause.
Okay, so you said you had 3 points, and I'm unclear if this probable cause point is a subpoint of A or if it is a second point.
Well, the trial judge evidently seemed to think that the defendant's consent was invalid because the police actually lacked probable cause to apply for a warrant, though they told him that a search warrant was an option.
Right. So do you have 2 other points, or?
Yes.
Okay.
Yes, Judge, I do. And first, the next point I should say is that The motion judge said that the police used the threat of seeking a search warrant if the defendant didn't give consent. Now, that's a mischaracterization of everything in the record here. There was no threat. The mere mention, I mean, it's well established, the mere mention of the possibility of obtaining a warrant is not going to somehow vitiate the defendant's expression of consent. And the defendant makes these claims in his brief about intimidation and arrest.
You might want to get to your third point because you have 18 seconds. You have one
Oh,
more
I'm
point.
sorry. The scope of the consent.
Scope.
All right. The court relies on Ortiz. That doesn't work here because in Ortiz there was ambiguity. Here there is no ambiguity at all. The defendant actually opened the safe for the police. So it's not we're not asking the court to interpret the words of consent.
Well, was there any issue about, I mean, if he was only accused of taking property that wouldn't have fit in the safe, was there any ambiguity then?
The police, by his consent, right, were entitled to search the premises for evidence of the crime, not just stolen items. He had told them he was posting these things on eBay. Sales proceeds, where better to look for corroboration of that than in the safe. I see I'm coming up on it, but let me just conclude by saying this. Unstated facts.
Actually, you're beyond your time for your conclusion. Did you have anything else you wanted to answer in terms of Justice Henry's question?
I'm sorry, I thought I did.
Has your question been answered, Justice Henry? Okay, so then you'll have to rely on your brief from here on in.
I'm done?
Yes, you're done by
Thank you.
a minute and 12 seconds.
Thank you
Yes,
very much.
Thank you very much.
Good morning, Your Honors.
morning.
Benjamin Brooks on behalf of Mr. Greeny. May it please the Court. I think that there is ample evidence here to support the judge's finding that the Commonwealth failed to meet its burden of establishing consent. You know, first you start with...
Let's just start with a preliminary point. I take it that you say this is a finding of fact, not a conclusion of law.
Right. So, yes, I'm just reading from the cases that Justice Wood mentioned, and I think it's clear, and it's been repeated numerous times, and it's in my brief, a finding of whether or not the Commonwealth has met its burden of establishing consent is a finding of fact. It is entitled to deference on review. It should be disturbed on appeal only if there is clear error. This is a limited form of review. If there is any resolution of competing facts that the judge makes, those are invariably accepted by the appellate court.
How do you reconcile that with the fact that the judge explicitly accepts the testimony of the two officers?
Well, I don't...
And credits their testimony.
Right. I think what the officers testified to established the fact that there was a coercion here, right? She didn't need to discredit their testimony in order to find that the circumstances that they described were coercive.
And coercive simply because the option was consent or we get a search warrant?
Coercive really for, I think, three reasons. One, because of the nature of the original approach. Mr. Greeny is at his job. He's a facilities worker, I guess a maintenance worker of some kind. The police approach him at his place of work from the very start. This is not a casual encounter. This is a targeted investigation. The chief of police comes with two high-ranking narcotics detectives. The police department has literally brought its top brass, its biggest guns, and its heaviest hitters to this encounter.
Is that in the record? I think one of the officers, one of them had only been there for 6 years or something. I mean, do we know it's really the top brass?
Well, there's...
Other than the chief,
There's
of
the
course.
chief, then there's a sergeant, and then there's a high-ranking narcotics detective, right? And I know the Commonwealth makes a big deal of the fact that Mr. Greeny was a former police officer, You know, so on the one hand, perhaps he had a better understanding of his ability to decline a request to search. But as a person, I don't think it made him any less susceptible to the coercive circumstances that he was facing. And
Well,
really,
pause there for a second. I mean, I feel like that's worth fleshing out a little bit. I mean, as a police officer, I don't know what kind of police officer he was. I don't know if he was more than a patrolman, if he'd ever served search warrants. That would be nice to develop. But if he knew the process of getting a warrant and he understood that they could get a warrant, and how long that would take, and freezing the property, I mean, it's not crazy to suggest that that's really relevant to the voluntariness of his consent.
if that were in the record, I think that would be a valid argument that the Commonwealth could make, and they didn't get that out. The only thing that we know about his status as a police officer was that it was probably long ago. He was a patrolman. At some point, he and Chief Oliveira were patrolmen together. And now we know that he's no longer a patrolman, right? And I think the power imbalance between them is kind of exaggerated by that, because Chief Oliveira is now the chief. He's coming to him with these other high-ranking officers to extract a consent from him. And I think his prior status as a patrol officer really only amplified that power imbalance and made him more susceptible to the police department's really forceful display of status and authority in those circumstances. So that's the first reason I think that this was, coercive circumstances to start. Then, even though my brother has said that he was never even remotely under arrest, he is informed that he's the target of the investigation. He's informed that they have probable cause to search his house. He's given his Miranda warnings as somebody who, as a patrolman, he would have understood was consistent with somebody who was under arrest or about to be placed under arrest. And then he is placed in the back of a police car. Whether or not it's a marked car or an unmarked car, I don't think really matters. And in some ways, I think the fact that it's unmarked is somewhat more intimidating and oppressive than a marked car. So that's the second reason that these circumstances are coercive, and it was certainly fair game for the judge to consider all of those circumstances that the detectives and the sergeant testified to. And then
I'm just going to interrupt you
reason,
for a second. It may not be dispositive, but what is your view on whether or not the police actually did have probable cause to obtain a search warrant?
Yes, so my view is that they didn't, right? Because
well, yes, I know that's your. Actually, you make that clear in your brief, but
Yeah.
There was, of course, the observation by the sergeant, I believe it is, Sergeant Lagoa, that seeing your client enter his home with a dartboard.
Right. So seeing a maintenance worker enter his own apartment with a dartboard, and then getting information from the defendant on scene before the search happens that this was discarded property, I think dissipated any
Let's back up for a
probable
minute.
cause at
He's
that
in
point.
a city-owned vehicle coming by on his lunch hour, and we do have the supervisor indicating to the chief this wasn't trash. So why isn't that come together to be probable cause?
Right. Well, I mean, in this hearing, right, they didn't present that information, right? All you had was the sergeant giving the information that he gleaned from the chief, but it was very unspecific about what it was. And there was no effort at all to determine whether or not his claim, right, which seemed eminently plausible, was invalid, right? And so I think for that reason, maybe they had reasonable suspicion at that point, but certainly not probable cause to search, which is probably the reason that they didn't go get a warrant and wanted to get him to consent. And I think this really is one of these cases where this was the whole point of their encounter with him, was to extract consent, and that matters, especially when they didn't have the probable cause on their own. So the threat to get a search warrant in order to extract consent, I think, is coercive. Consent is not valid when it's given only in acquiescence to a claim of lawful authority.
The Commonwealth cites a case, and I don't have it at my fingertips, that just the threat of getting a search warrant is not coercive.
Well, I think all of those cases, the language that they use is the mere mention of the possibility of getting a search warrant doesn't invalidate otherwise valid consent, right? And so I think there are two things going on. One is police did more than just merely mention the possibility of getting a search warrant, as Justice Wood quoted from the transcript at the beginning. The officer was specifically asked, he was given basically an ultimatum. We're going to go get the warrant, or you sign this consent form, right? And that is different than saying, we could go apply for a search warrant, but you could give us consent now. And I do think that, as I read these cases, I was sort of surprised to find this, but Bumper really is an interesting and important case here, because in that case, the officers present the occupant, the defendant's grandmother, with information that they have a warrant, and she says, go ahead and search. And then it's at the hearing that they decide they're not going to rely on the search warrant. In fact, they did have a search warrant, apparently, or at least that was represented. But they didn't rely on it in the hearing, right? And so the court said, listen, mere acquiescence to a claim of authority is not consent. And that's really the end of the story. So in this situation, you don't really actually need to go beyond that, because in this case, it's clear on these facts that what Mr. Greeny was responding to was the assertion of authority, right? And that was the only reason that he gave his consent. I think that line of cases that the Commonwealth cites that stand for the proposition that the mere mention of the possibility of obtaining a search warrant isn't going to undo an otherwise valid consent are really instances where there's numerous indicia of consent, right? And then the defendant in challenging it says, hey, wait a minute, during one of these encounters, the officer also mentioned the possibility of getting a search warrant. So we're going to try to bootstrap that fact and render the entire consent invalid. And the court has said, no, in those circumstances, when there's other indicia of consent that's valid, just mentioning the possibility of securing a search warrant isn't going to be enough to undo the consent. But that's not what we have here. And then I think it's a question that doesn't actually need to be answered. And I probably spent too much time on this in the brief. But
Is this your third point?
Yes, if that's the standard, right, that merely mentioning the possibility of getting a search warrant isn't going to undo consent, I think in those circumstances, they better have probable cause to do it. If they are inserting their claim that they can get a search warrant into the conversation with the defendant, then they better actually have probable cause in order to get that, if they're going to then rely on the consent that they get to extract it. So I think the formula, which I think works for all of these cases, is that consent does not validate an otherwise unlawful search when it's procured by an officer's assertion for an authority that doesn't exist, right?
Okay, but unless they've actually gone and tried to get the search warrant, then they haven't tested whether they have probable cause.
Right.
Right. So had they gone up to him and said, would you just consent to us searching your house, and they didn't mention a search warrant at all, you agree they had the right to do that, and he could consent and the search would be fine?
Sure, because they're not inserting any authority that they don't have into the equation, right? They're not saying, hey, we're gonna search your house anyway, so you might as well give us consent.
So if we think that there was probable cause, or that they could have established probable cause because they could have put in the supervisor's statements and or an affidavit from the supervisor, and then they have the detective go and observe him in a city-owned truck during a work shift, albeit at a lunch break, walk a dartboard into the house and come back out. If we say there's probable cause, then what happens?
Right, well, I think then you're in the same posture that Bumper was in, right? Because it's actually just acquiescence to a claim of authority. That's why he gave the consent, right? And if the Commonwealth failed to produce that at the hearing, then it's on them. But I also, well, to backtrack, I think it is, the rule is in Bumper and Schnet, I can never pronounce that.
Cloth?
Yes, thank you. That one's hard. If the consent is extracted just in acquiescence to a claim of authority, then that's not consent, right? And then you'd have to show, even if they had probable cause, that doesn't really come into the equation. And certainly they didn't have any exigent circumstances here, which would have justified a search without a warrant.
Can I, assuming anything that happens in the basement is relevant, your opponent says something to the effect that clearly Mr. Greeny consented to opening the safe because he gave him the code. But you cite, the transcript cite 10 and 48, Mr. Greeny told the police he did not want to open the safe. Is that relevant to that?
I mean, I think that demonstrates the power of the coercion that they were using against him to get this search warrant, right? He says, I don't want to open the safe. They say, come on, Mr. Greeny, we're just going to get a search warrant for it. You might as well just open it for us. And then he ends up doing it. So that is, I think, the definition of acquiescing to a coercive circumstance, right, and to a coercive statement.
I'll see if the panel has any further questions. I don't, and you still have 40 seconds if you want to conclude, please do.
I would just conclude by saying I think this is a case where there are a lot of layers that the court has to cut through in order to undo the judge's finding here. I think the finding that she made, that there was a lack of consent, is a factual finding. It's entitled to deference, and the court should uphold it. Thank you very much.
Before you leave, I presume this case is pending? Is that what is going on in court right now? The case is pending?
It's pending in the New Bedford District Court, I think.
All right,
Yes.
okay. Thank you very much. We'll take the case under advisement and get an answer to you as soon as we can. Thank you. The court's in recess.
All rise.
Thank you. The next case before us is case number 2024-1105, Michelle Mangino and another versus Paul Capizzi and others. Counselor?
Good morning, Your Honors. Matthew Hamill on behalf of the appellant City Solicitor Paul Capizzi, who is seated to my left here, although he may have to depart in a few minutes to attend to another matter. Your Honors, we are here seeking the reversal of the Superior Court's denial of our motion to dismiss based on the litigation privilege, because the conduct that is alleged by plaintiffs in their amended complaint fits comfortably within the paradigm of that privilege as it has been applied by both this court and the SJC. With due respect to the Superior Court, our argument today is going to focus on what can essentially be distilled into three areas of disagreement with that decision and three errors. Number one, the Superior Court erred in concluding that the conduct by Attorney Capizzi in disclosing the investigative report was not preliminary to or during the course of litigation. Number two, the Superior Court applied an overly narrow standard to the related to element of the privilege. And number three, I would suggest, again with all due respect, that the Superior Court focused too closely on the email itself as opposed to the investigative report.
So I find it helpful to just really make sure we're all on the same page as to the fact. So just briefly and quickly, I take it your client did not have an appearance in the MCAD proceedings. I realize you are going to tell me that doesn't matter, but I just want to be, for us to go through the record to prove that takes a lot of energy, whereas if I can ask you a 10-second question and get an answer, we're done. So he didn't have an appearance in the MCAD proceeding, right?
That is correct, Your Honor.
And the Ryan report would have been completed irrespective of the MCAD proceeding, right?
I do believe that is true, Your Honor, yes.
And was there any connection between the Ryan report and the MCAD complaint, or was it just that they both dealt with some of the same underlying allegations?
Absolutely. There was, I think, a very strong connection between the Ryan report and the MCAD proceedings. In fact, the MCAD proceedings were attached as exhibits to Attorney Ryan's investigative report. And I would be happy to direct the court to a few additional allegations that I think are very relevant here that are alleged in plaintiff's amended complaint. Attorney Ryan investigated and asked questions of the plaintiffs, and this is in paragraph 91 of the amended complaint, Your Honors, about the filing of their formal complaint to the city, which then triggered the hiring of Attorney Ryan to conduct the investigation in the first instance. That's all alleged in the amended complaint. So I would suggest that there's a very strong relation, Your Honor, between the Ryan report and the MCAD proceedings.
But Attorney Capizzi gave the report to, among other people, the union president. I don't want to get his title wrong, but am I correct that he had no role in the MCAD proceeding, the union president?
The union president had no role in the MCAD proceeding. However, the allegations in plaintiff's first amended complaint discuss several allegations concerning grievances that the plaintiffs had filed either individually or collectively against the city, including, as relevant here, Your Honor, I would suggest allegations about a disparity in stipends. And that disparity in stipends, Attorney Ryan, again, this is paragraph 93, Your Honor, of the amended complaint, asked specific questions about that stipend disparity as part of her investigation.
So is the argument that the causal connection that Attorney Capizzi gives this Ryan report to the union president because of its relevance to the grievances? Because it seems to be contradicted by what he actually said, according to the record, in this 12b6 posture, that I gave it to everybody because of my duty to disclose public information to the public, or this information to the public in the duty of transparency. Do I have that right?
Well, Your Honor, I think that goes to the preliminary to aspect of my argument, and I'd be happy to address that. But in terms of the causal connection and the related to element, I would suggest that Attorney Capizzi's disclosure of the investigative report in his role as the chief legal counsel for the city, as city solicitor, was a statement of the city's legal position with respect to these grievances. and that is absolutely protected under the privilege as it's been defined in Basicus and other cases by this court.
Right, but my question was, given that he said he disclosed it for some other reason, not that reason, and that this is a 12b6 phase, doesn't it seem that there's at least a factual dispute about his real reason for disclosing this?
Well, Your Honor, I don't believe you, your point is well taken, Your Honor, but I don't believe we get there in a litigation privilege analysis. So Attorney Capizzi's intent or motives in disclosing the investigative report, I don't believe are relevant under the litigation privilege analysis, which applies.
Sorry, just to pause, that's actually shockingly surprising to me. Let's say there's no dispute that he turns this over to somebody else for salacious reasons, having nothing to do with his role as city solicitor. And let's just assume that somehow we know that that's what happened. You're saying because he's the city solicitor, it doesn't matter. Strict some sort of strict liability. It doesn't matter why he turned it over.
What I'm saying, Your Honor, is that the cases of this court and of the SJC have concluded that such allegations are not pertinent to the litigation privilege analysis, and that it is not any allegations of animus or bad faith really do not come into play. It's an absolute privilege for conduct in the institution of during the course of a judicial proceeding.
So opposing counsel said in his brief, and he's going to get up and argue in a few minutes, that for the litigation privilege to apply, your client would have had to have been counsel in the matter. So what's your response to that?
I respectfully disagree with that position, Your Honor. I think that, number one, takes too narrow a view of the litigation privilege. I think if we were to adopt that view, we would severely hamper the privilege application in situations preliminary to litigation, which this court has repeatedly held that it applies to. I would point to the Doe versus Nutter case. It applied to a demand letter in that case, pre-litigation. The Visnick case, which we cite heavily in our brief, which again involved a statement of mere intention to file claims in the MCAD and the EEOC. So I do not believe that is dispositive at all, Your Honor. And in fact, I believe that Attorney Capizzi's disclosure of the report was in preliminary to litigation was absolutely proper under litigation privilege, in so much as the MCAD is, as this court is well aware, a conditioned precedent to filing suit in the Superior Court.
Sorry, could you say, I just didn't understand that last phrase. I didn't understand what you said.
Yes, Your Honor. So claims in the MCAD are there's an exhaustion of administrative remedies requirement. So that's a conditioned precedent to filing suit in the Superior Court. And so I think that goes to relation to litigation. I think that litigation was absolutely contemplated in good faith at that point, Your Honor.
So when you're relying on litigation or preliminary to litigation, are you relying on anything other than the MCAD proceeding? Are you relying on the grievance as a separate potential litigation?
Your Honor, I think we're relying primarily on and I think the allegations in the amended complaint bear this out. There's a complaint through counsel to the city. MCAD complaints are filed. The disclosure of the report happens all after that. Excuse me. I think the fact that MCAD complaints were pending at the time would suggest that litigation was contemplated and in good faith and under serious consideration. I mean, I think even if you look...
So I get that, but are you also relying on the grievance?
No, Your Honor. I think that would be a factually dependent circumstance. Certainly if it was a grievance arbitration, I think then the litigation privilege does come into play, but I'm not independently relying on the grievance itself.
What does the union president have to do with the MCAD proceeding?
The union president, the MCAD proceeding, raised allegations concerning these stipend disparities. We have an Equal Pay Act claim in the Superior Court complaint that we're here for now. So the union president was involved in those grievances that are alleged in the complaint, and the city hired an investigator to investigate those allegations, and City Solicitor Capizzi, in his capacity and function as a city solicitor, turned that evidence over to the grievance, and I think that's a statement to the union president, and I believe that's a clear statement of the city's legal position.
So what is the significance, if any, of the allegation in the complaint that your client's disclosure ran contrary to his routine practice of not releasing records, and that, and here the city had not received any public record request.
Your Honor, I think that again goes more to the sort of the not goodwill aspect, which I don't believe comes in under litigation privilege analysis. So litigation privilege can apply regardless of bad faith, and I believe—
You're saying your client could have just posted this on a billboard in Revere or put it up on the Facebook page because he's an attorney and there's an MCAD proceeding?
Your Honor, I think the litigation privilege is it's certainly a fact-bound inquiry. I think, at least under the restatement's broad formulation of it, an attorney, as long as it bears some relation, an attorney is absolutely privileged to publish defamatory material in that manner.
So that's what I'm trying, we do this in many of our cases, like what's the outer limit here? Because that test, some relation, means he could put it on Facebook.
Yes, Your Honor, and that's a fair question. Again, I think in terms of the outer limit, Your Honor, I don't know. I'm just here arguing, but I would submit that the conduct in this case, again, and I think we cite a number of cases in our briefing, Visnick and Dover-Snutter, I think are probably the strongest for this preposition, but an attorney's, for example, statement in response to a demand letter in anticipation of litigation is absolutely privileged under the litigation privilege. And I think the disclosure of the investigative report in this circumstance, I think fits comfortably and is quite close, I would submit, to the Dover-Snutter case.
Does it matter whether or not he knew that Ryan had promised the plaintiffs confidentiality? Let me back up. Is there any dispute of fact about whether Ryan had promised the plaintiffs that she would not release their interviews absent some sort of legal compulsion?
I don't believe there is, Your Honor.
Okay. Is there any indication as to whether or not your client knew she had made that representation?
I don't believe that's in the record, Your Honor.
Let me ask you a question about more of an inner, not outer limits, but more on the inside of that. And that is, this report contained personal information, phone numbers, addresses, et cetera. Does that come into play at all with respect to the litigation privilege? Is there any kind of conflict there between the privilege itself permitting publication of documents without any consideration of malice when there's personal information contained within those documents?
Your Honor, it's an interesting question, and I'm not sure that there's a case directly on point that I could direct the court to address that question. I don't think that matters. I think the claim, again, is that this report was one entire defamatory submission. And I think, again, based on Vasquez and the cases from this court interpreting the privilege, I think the privilege has been applied to the Vasquez court noted that the privilege is necessary to promote candor and the exchange of information as it relates to litigation, and accepted those broad provisions as necessary to fulfill that goal. And so I think—
But then if we recognize your argument here, it does the opposite of promoting candor as part of the grievance or the investigatory process. No city employee in their right mind would cooperate with you absent a subpoena and real assurances of confidentiality. So what you're asking for very much undermines the goal of the litigation privilege.
Well, Your Honor, I again would suggest that Attorney Ryan's investigation focused really directly on what is now alleged in their Superior Court amended complaint and tried to get to the bottom of that. And I think the city hired Attorney Ryan in response to these complaints through counsel to the city of discrimination and harassment, and provided the statement of the investigative report as a statement of the city's position the report found that there was no merit to the allegations. And I think that does go to the litigation's privileged goal of avoiding these cases and promoting zeal and...
But no witness in the city of Revere is ever going to say anything if they know that the city is going to turn around, is going to have an agent say, I'm keeping this confidential, and they all have to now assume, if this is allowed, that that is an empty promise.
Your Honor,
I mean, if I'm wrong, I really would like you to tell me that I'm wrong. But I don't see how anyone with a brain would trust the city to maintain any kind of confidentiality if, in fact, we agree with you.
Your Honor, and I see my time is just about up. May I answer?
Yes.
Sure.
And then there's one more question from no, it's been
No,
answered? Okay, all right,
Justice
go
Henry
ahead.
asked the
Thank
same
you.
question.
Thank you, certainly. Again, Your Honor, I would suggest that an entire purpose in the context of this investigation and the investigative report was an effort to get to the bottom of the allegations and stave off the very litigation that we're involved in, and that Attorney Capizzi's disclosure of that was in furtherance of that goal, which I do think supports the public policy behind the privilege as it was articulated in Vasquez and other cases of this court. If the panel has no further questions, I'll respectfully rest on my brief. Thank you.
One moment, I'll check with, okay, all right, thank you very much.
Thank you.
Counselor?
Good morning, Your Honors. May it please the Court. Joseph Sullivan for the plaintiff's appellees. I'd like to respond to and address the litigation privilege. And because of some, I think, misstatements of the law or misunderstandings, I'd like to just read the litigation privilege as it's stated in the restatement and in the Gillette case 91 Mass Appellate Court 140. This is how the privilege is defined. It's an attorney at law is absolutely privileged to publish defamatory matter concerning another in communications preliminary to a proposed judicial proceeding or during the course and as part of a judicial proceeding in which he participates as counsel, if it has some relation to the proceeding. And the point I emphasize is very critical here because I think it's ignored by the defendant and by Attorney Hamill here. This court, of course, in the Superior Court had to evaluate their assertion of privilege here under the Rule 12b6 standard, as Justice Wood pointed out, and under the well-pleaded facts and any inferences drawn.
But if we had rebuttal here, he would get up and say, well, they were in the preliminary run-up to litigation, and so his client would have been counsel for the city somehow. I have no idea how big their law department is, but that's what he would argue. So what do you say to that?
I would say that's simply not a reasonable inference from the well-pleaded, from the facts from the complaint, Your Honor. What the complaint alleges simply is that Attorney Capizzi was a city solicitor. Then if you go to the other facts of the complaint, which are paragraph 107 to 108 to 109, it's Capizzi sent the email with the final investigation report to the plaintiffs. Capizzi sent the email also to the current union president, which included the exhibits.
So he also argues that, the dispute is over the email Capizzi sent. So I'm asking you, is the dispute over the email Capizzi sent, is it over the sending of the Ryan report, or is it both?
It's over, that's a good question. Thank you, Justice Henry. It's over the email. We don't, of course, have a claim of defamation against Attorney Ryan, and we can, that's for not to discuss here today. The dispute and the claim is over sending the email. Of course, the defamatory statements are contained, we allege, in the underlying report, but the action that gives rise to the claim is the sending of the email, because that then disclosed the report to unauthorized recipients, such as the union and union members. It's the sending of the email, which we then, in other paragraphs 119 to 123, we explain and allege went against standard practice. Attorney Capizzi is well-versed in the public records law, where our client, the plaintiff, Captain Mangino, worked with him on public records, knew his practice. He never did this, so this was against his regular practice. He always opposed public records, but we allege, released this just as a gratuitous effort to sort of retaliate against him, we allege in one of the paragraphs.
So one thing that I'm confused about both of your arguments is if somebody files a complaint, say a personal injury complaint in court and says, he raped me, then that's definitely subject to the litigation privilege. But if they then go out into the, government center and say, he raped me, isn't there an argument there that that could be defamatory and would not be protected by the litigation privilege?
I would certainly think so, yes.
So why isn't this email like CAPIZZI doing that, going out to government center and just making a?
I certainly think it is, Your Honor. I don't, that's a second, my first argument is that he's simply not representing the city here.
Okay.
The second is that this has no relation to the MCD complaint, the case.
Accepting your point that he could be, well, just focusing on the grievance process, their observation that there was a grievance pending, the union president has a role in grievances, so Attorney Capizzi is giving them relevant information, him, the president of the union, relevant information on this. Why is that not permissible?
I would argue that on a summary judgment, perhaps that evidence comes out, perhaps it is. This is a Rule 12b-6. There's simply no allegation in the complaint. That's no reasonable inference can be taken from the complaint. We allege the complaint, and this is because we know we knew this at the time we drafted it, that when we questioned Attorney Capizzi, why did you send this? He says, it's a public record. I'm sending this because it's a public record. He could have said, I'm sending this to this union because he's involved in the grievance. He didn't say that. He said it's a public record. So that's the inferences that the court can draw, and that the Superior Court did draw, as that's the reason he said. And that's why we alleged, you don't normally do this when you do your public records, and we know this because Captain Mangino works with him on public records. So, but going back to what I was saying, the complaint is replete with allegations about the MCD process, and there's no allegation in there about Attorney Capizzi's role in that. And so there's simply no inference that could be drawn that he was representing the city as part of this process. It certainly was going on.
He would have had to have filed some sort of affidavit and tried to turn this into a summary judgment?
A summary judgment, yes. I mean, and the defendant makes the point, you don't have to file an appearance no, we don't claim you do. But there has to be some reasonable inference that could be drawn that he was representing them, that we allege he filed responded to a demand letter, some kind of reasonable inference. It's just not there.
I mean, stepping back far enough anyway, there's a reasonable inference. He's the city's lawyer, and these are complaints about a city unit, the police department, and so as the city's lawyer, everything he does about this complaint is in his role as the city's lawyer. Why does that break down?
Because that would simply expand the litigation privilege beyond all bounds. I forget which justice it was, talked about limits here. I think that would, Justice Vuono, I think that would take the privilege beyond any reasonable bounds. If we can analogize this to a corporate defendant or a corporate counsel, and one lawyer that gets sued for maybe defamation, and you'd want to know that lawyer was actually involved in the underlying litigation. Otherwise, all lawyers at that firm or corporation could enjoy the benefit of the privilege, and that's not by the express terms of the I don't know how to pronounce it, Besichis decision and the actual restatement. That's not the intent. It's not the intent to insulate all lawyers at a corporation or all lawyers at a firm from any claim of defamation just because one lawyer there had happened to have been involved in an underlying dispute. So that's my response. And
you argue in footnote 4 of your brief that Defendant Capizzi could have attached his email to his Rule 12 motion without transforming it into a Rule 56 motion, but he didn't do that. Instead, he attached a subsequent email between himself and plaintiff's counsel, and that undermines his claim that the email relates to the MCAD proceeding. I didn't follow that. Could you just explain it?
The point I was making there is that the email that I referenced as the defamatory email was the email that he sent to the union council, where
President, not council, right?
Right, and if he wants to claim that he's taking part as in the MCD, he could have attached that email or any email to claim that he was representing, taking part of the MCD, but he did not attach that email. He attached another email to show, to prove something else, and I don't quite recall which email it was, but that's the point I was making. I had arguments to prepare for the other community, common law immunity and conditional privilege, but since that was not raised I assume that's waived, and there are no other questions by the...
No, they can rely on their brief.
Oh, yes, and so I will rely on my brief for those other arguments, and if there's no other questions...
I'll be checking with the panel, one moment. No? No further questions. Thank you both very much.
I'll rely on my brief.
Take the
Thank
case
you.
under advisement. Okay. All right, you've just made it to the afternoon, so good afternoon, Counselor. You'll be arguing by yourself today. You're appearing, and the other side is not going to be here.
Yes.
I'll call the case 2024-0979. As you know, the case is partially impounded, so we won't refer to anyone by their names, only by their initials. M.M. versus M.J.M.
May it please the Court, Dana Curhan for, I'll refer to him as the defendant.
Okay.
And here is the problem in this case. There is no evidence of imminent physical risk to imminent physical harm. There were one or two incidents that took place in 2018 while the parties were still married. She found out that he was...
Jump forward. Why can't the judge have relied on and considered those events in issuing this 209A order?
The judge, the judge can certainly rely on them, but I think we have to, every time that it gets renewed, let me step back for a minute.
Mm-hmm.
There were, if you read the plaintiff's affidavit, she talks about, things got physical, sort of in the passive voice. She doesn't say that he attacked me. Essentially, it's not clear, and, we contend that actually the wife got physical, and one of the occasions he took her and pushed her out the door. Okay, so in the context of a marriage that is failing, and clearly this one was, there are things that happen. Now, does that mean that there should be a lifetime order?
Well, there's no lifetime order.
There's no lifetime order, but it was issued and it was in effect for a couple of years, and then it lapsed. And then the wife went in and said, look, let's have this probate order that essentially does the same thing. The problem with the probate...
I'm not so sure the wife said that. The court issued an order. There was an agreement issued by a judge of the probate and family court, correct?
Right.
Which the wife decided would be sufficient to protect her under the circumstances.
This was an agreement that was approved by the probate and family court. The real problem here, and having been a coach with youth sports, is that the son is now playing football.
Oh, I'm familiar with the scenario here.
Sure.
But that, and as the judge said in this hearing, we deal with this all the time. Not we as in we, as the judge said, we deal with it as in that court all the time. And it seemed as if the 50-yard prohibition was working just fine until your client decided that was not going to be followed anymore.
It's not just the 50-yard prohibition. There's like two steps. If he's going to be someplace where she is going to be, he's got to notify her in advance, and she is then got to give permission, and then he's got to stay 50 yards away. So what that means is every other week, When a game takes place on her parenting time, she says, "You're not going. I don't give you permission." And
as I understand it, she can't go to his games either. Go to the son's games when the son has parenting time with your client.
that may be the case. I don't think there's anything in the record that he's
Well, that's what the judge told her at the end of that hearing.
Yeah, but I don't think he's ever denied her the ability to go to his games.
Okay.
She has denied him the ability to go to his games.
Could I circle
Yes.
back to two things? Imminent risk of serious physical harm. So you make the point, I guess, that whatever abuse may or may not have occurred in 2017, 2018, that's many years ago, and I guess your argument is that the danger dissipates. But I'm focused on much more recently, this probate court order, and he specifically says, according to my understanding of the record and your recitation of it, I'm not going to follow that order anymore, which fact, I mean, sure, your gloss is, because I want to go to the football games, but her gloss is, so I'm going to be coming within 50 yards of you. Why is that not an imminent risk of physical harm?
Well, I mean, it's an imminent risk of unpleasant contact. I don't think there's any evidence that there is an imminent risk of physical harm. Keep in mind, they have done hundreds of exchanges of the child and the equipment within the 50 yards, and there have been no further incidents. You know, he's now married, he's got 2 children, he's got a new family. I mean, at some point, I think this has to end.
Well, he's saying, I'm sorry to keep belaboring it, but to me this is important. He's saying, I'm going to disobey a court order. What are we supposed to do? That seems ominous to me.
Well, I mean, I don't
Am I unfairly characterizing it? Because I'm trying not to, but it seems like that's what he's saying. I am disregarding a court order to stay away from you.
I think the remedy is to go back to the probate and family court and file a contempt. It's not necessarily to go back in and get a new 209A order. And, you know, that I think is the real problem.
Well, that wasn't the
Procedurally-
argument, though, below.
I mean, procedurally, she has the option of seeking a new order, or she could have gone to seek a contempt, right? That she's not limited. I mean, she has to satisfy the conditions for the order, and I get that you're saying she didn't.
Yes. And I mean, technically, you know, she does have the option of doing either. I think where there has, and, you know, if he had attacked her, if he'd assaulted her, sure. She should go back, she should go to the district court, or whatever court is most available to her. But in the case of in the present context, where it's been, at the time she got the order, it was 5 or 6 years after the last incident, the parties are long since divorced. I think her remedy really is to go in and do.
She's saying that there were still skirmishes, and even to this year, there are skirmishes going on in the probate and family court, that yes, it was in the past that your client allegedly physically assaulted her to the point of a broken rib and his arrest, but that was part of a years-long pattern of abuse and intimidation, and you can take the whole package together. Why is she wrong about that?
Why is she wrong? I think.
You can take the whole pattern and package together.
Well, I mean, I think what you have now is you have unpleasantness. You have a lot of unpleasantness, and that's not what 209A is for.
The judge disagreed with you. You think it's unpleasantness. The judge heard both parties and decided it was far more than that, than unpleasantness. So what about the judge's decision is actually wrong? Not just your interpretation of what you think these two parties, their relationship is, if I may be so bold to say. Where did the judge go wrong?
Well, where is the threat, I guess? Where is the danger? Where is the physical,
Our
danger?
case law says that can stem from prior physical assault.
It can. It's my contention, though, that in the present circumstances, you have unpleasantness between the parties, but you don't have the type of, and the degree of hostility that would warrant issuing an order, a 209A order.
On this record, could the judge have concluded, or did your client basically admit that he lied about what the police sergeant said and he lied about what the neighbor said?
Yes, yes, he admitted that. And again.
So what could the judge make of that? Fairly.
Does that put her in danger?
Well, it certainly arguably shows an effort to control her in a way that many people would consider quite alarming.
Well, I mean, but not control her physically.
Well, but you add that to the past physical abuse.
I would look at this as, certainly there's a lot of controlling, but I think it's on her part. I mean, she's using this order not necessarily.
You don't want to make that argument. I saw that argument in your brief, that she's using the courts as a tool. She received an order from a judge whom I think we can say looked at the evidence impartially.
I mean, I'd say so, but I have a lot of cases where there's a divorce, and in the context of a divorce, an order is issued. Now we are well beyond the divorce, and I think there is cooperation between the parties to some degree. There have been exchanges, hundreds of exchanges of the child, of the equipment.
A positive point, no question.
Yes. But I don't think we have anything more than anything that creates a risk of serious physical harm. I think it's probably time to move on. I think when he said that he wasn't going to follow the order, in the absence of any new incidents, any new violence or threats of violence, I think the remedy was to go back to the probate and family court and litigate this, have him held in contempt, have the order modified.
One thing that jumped out at me, and I couldn't really believe I was reading this correctly and didn't understand, but that at one of these games that seems to be a flashpoint, he flew a helicopter over the game. And did I get that right?
Well, that was after.
Yeah.
That was after this order issued.
Oh, okay.
This is the end of the month. She claims she saw a helicopter fly over, and she said, well, that's him. That's his helicopter.
I thought, my recollection was a little bit different. Maybe I'm wrong, but that she asked her son, and her son said, oh, yeah, that's Dad. Dad's in the helicopter.
Yeah.
I could be wrong about that.
I mean,
That is in the supplemental appendix.
So what struck me about
I know you've moved to strike, and so the panel will take that. The panel will take that under consideration afterwards.
Okay.
Yeah.
All right. Well, then.
No,
that's
just.
But to the extent that we decide to consider that, I guess I'm trying to a fair question. How is that relevant to anything? I guess what I'm wondering, is thinking out loud is, it seems like he doesn't like rules that constrain him, especially around his son, and if he loses his temper about these rules, bad things have happened in the past. And that seems to perhaps support an inference of imminent risk of serious physical harm. Is that, where's the break in the causal chain there that's unreasonable?
Well, I think that's really a stretch. I mean, I think he says, I want to go to the games. Every other week I don't get to go to the games because she doesn't give me permission, and I don't get to go.
Right. We're arguing about, I hear your point at the beginning.
Doesn't like the rule.
And he doesn't like the rule about kids playing sports. I guess what I'm struggling to articulate is a sense of scale and proportion here, where there's a history of allegations of serious physical domestic violence. Like, I know it's heartbreaking I can see the perspective that it's heartbreaking to not get to watch your 8-year-old play football, but maybe you don't make that argument to this person, your ex-wife?
I mean, ideally, what he probably should have done is he probably should have gone into the probate and family court and say, let's modify the order. He didn't do it. It wasn't the right thing to do, but again.
And doesn't that, and the failure to do that, support her inference of the reasonableness of her clearly, powerfully articulated fear of imminent risk of physical harm?
Again, I'm going to say no. I'm going to say that it is a lot of unpleasantness, and that unpleasantness should be sorted out in the probate and family court. not necessarily through a 209A. I don't think I have much to add at this point. Unless there are any further questions, I will rest on my brief.
Okay, I see no further questions. Thank you very much.
Thank you.
Okay, now we're coming up to our last case of the day today, case number 2024-0424, Kevin Norris versus the Massachusetts Parole Board. Good afternoon.
Good afternoon. Good afternoon, Your Honors. May it please the Court, Matthew Coase here on behalf of the plaintiff, Kevin Norris. The Superior Court in this case should have decided Mr. Norris's declaratory judgment claims on their merits. In his complaint, Mr. Norris raised important legal questions about the parole board's ability to infringe upon his constitutional rights and the parole board's authority to revoke his parole based upon an alleged violation of those rights. The declaratory judgment
Their argument is that you didn't plead it enough to get to the declaratory judgment because you had to show this, that this was generally a generalized harm, that there was a clear and repeated generalized harm of these parole conditions, and really all you have is that two sets of similar parole conditions were imposed on him, and there's this shorthand of Sex A conditions, and that wasn't enough. So what do you say to that?
Well, I would say with respect to that argument, that was Judge Bell's argument on the second motion for judgment on the pleadings, if you will. I disagree with that. I think in the complaint it's clear that those sex offender conditions are the default conditions for any parolee who has been convicted of a sex offense.
Can we get specific? I hate to put you on the spot, but the paragraph numbers in the complaint, because that's what I went through, scouring it for those specific generalized allegations. Do you have paragraph numbers?
I'm not sure I know the specific paragraph numbers off the top of my head, but I think it was count 2 was the declaratory judgment. My guess is
that's right.
There was probably somewhere around 120 paragraphs in the complaint, and it's towards the end.
Right. So, I mean, paragraph 94, the parole conditions that restricted Mr. Norris's internet and smartphone usage were not reasonably related. The monitoring of Mr. Norris's internet and smartphone usage constituted an unreasonable search. I think the problem here is one of pleading, to pick up on Justice Henry's point, that it's not okay under the Declaratory Judgment Act if it's merely infringing on his individual constitutional rights. You have to focus on a regulation or propriety of practice involving violation of rights which are consistent and repeated in nature. In other words, everybody. And while it may be true that the Sex A provisions apply to every sex offender parolee, you have to allege it. So the question is for us, I think, a really technical one. Did you allege that? Allege not that it was merely him, but did you allege that this creates the same problem for all sex offender parolees? I couldn't find that in the complaint.
Well, I don't think that the complaint specifically says that the Sex A conditions apply, but I think it's implicit to the Sex A conditions which are appended to the complaint. And I think
thought about that. Do you have a case that I have the complaint here and I have the appendage, which is the Sex A guidelines, which is, I guess.
I don't have a case off the top of my head, Your Honor, but I'd be happy to supply one to the court. But I am familiar from my practice in the civil area that there is some case law to the effect that anything that's referenced in the complaint or appended to the complaint is part of, can kind of be considered with respect to the general pleadings. I would also suggest that this kind of area of or argument suggests that there's a kind of a heightened pleading standard, which I don't think actually exists. I think when you look at the declaratory judgment statute 231A section 9, it says that this statute is supposed to be administered liberally. And I would also point the court's attention to Mass Rule Civil Procedure 8, which similarly says that, you know, the allegations are supposed to be construed to do justice.
But why not walk out of here today or the minute you got their brief and just file a properly pled declaratory judgment action?
Well, I would suggest that what happened here was the first Superior Court judge kind of put the cart before the horse by remanding it back to the parole board before Mr. Norris got a chance to address these constitutional issues. So when the first Superior Court judge remanded it back to the parole board, we're back dealing with a parole revocation hearing.
That was by agreement, is that correct?
Actually, no.
And Mr. Norris didn't say, nope, I don't want to have another hearing. I would rather litigate these constitutional issues.
Yeah, we did file a reply brief. I think if you look at volume 2, it's on pages 199 and 200. I basically make the argument that, you know, this same issue is not going away. It's going to arise. We're going back to the parole board.
I see that, but was there any disagreement about going back to the parole board for another hearing?
Well, that was the court's order, so we followed the court's order. But the court didn't really specifically make any sort of findings. The court basically said, you know, the parole board wants to remand it back, so I'm going to do that. But like I said, I did make the arguments that, you know, we're going to go back to the parole board, but these fundamental issues, you know, whether or not the parole board has the authority to revoke him on these issues is key. And I understand we get back to the Superior Court the second time, and then now that we're kind of in procedural no man's land, he can't address those constitutional issues because they're saying, well, it's moot or he didn't plead it properly.
Right.
But,
so you're not in no man. Well, the way I'm hearing it, you're not in no man's land. The solution is to file a new complaint in which you properly plead it.
Well, I don't understand.
Especially because he's now been granted parole with new conditions. So file a new complaint. And I mean, yeah.
If I could respond to that, I mean, when he went back to the parole board, they actually found him in violation of all of those same exact allegations. They re-paroled him because the parole board has that authority. Even though he was found in violation, they can continue to re-parole him.
So I don't mean to cut you off, but it sounds like you're, and this happens a lot in these briefs, you're merging mootness with the adequacy of the pleading. Like, it sounds like you're sort of saying, it's not moot, it's going to be repeated, so let's address it. I get that, but I disagree with that. I'm not, but we're not talking about mootness, I think. I think we're talking about the adequacy of the pleadings on this re-parole. He's now been re-paroled with new conditions, so, and the problem I'm having is that you have not, under my reading of the rule, and as interpreted in Diachenko, adequately pled this as something that's appropriate for declaratory judgment relief. And so I'm not concerned about mootness. I'm concerned about the adequacy of your pleading. And I guess you've already answered what you can answer, which is this construed liberally and the attachment is there.
Well, my argument is certainly it is to be construed liberally, that the parole conditions, I think when you read the parole conditions themselves, they say, you know, the general conditions say that if you are convicted of a sexual offense, then you are required to follow the Sex A conditions. And then when you read the Sex A conditions, it says, you know, if you are required to register to level 1, then these are your conditions, level 2, so on and so forth. So, you know, again, I'm arguing that it's clear from the document itself, which is appended to the complaint, that these are the default conditions. And
even if we were to rule fairly quickly, you're going to wait. And I think, unless she gets up and tells us otherwise, you could go into court today and get what the relief you're seeking from us. You could just file a complaint with broader allegations. on the DJ part. You got a different problem on the cert part, which is that the original action was not timely filed, and he didn't seem to properly file on the re-parole conditions. That's a different issue, but on the declaratory judgment, it seems like you could have gone back into court any time. Is there a reason, if we're wrong, is there a reason you couldn't have just gone back into court and said this applies to everybody who's got a sex offense, and then you're done? You're not waiting for us for however long, weeks, months, to rule?
Well, I mean, there's certainly some practical considerations in terms of the scope of my assignment through CPCS, but we're also talking about a situation where this is a person who's been found to have violated these particular parole conditions. And now he's being viewed as a parole violator because he had violated these parole conditions. And the parole board has been quite clear about it in his pleadings. He's now being held to a higher standard. And when he was re-paroled, these same exact parole conditions jump back into place.
But so if we do what you want on this first question, then get past the adequacy of the pleading and agree with you, I can't figure out how we can do anything more than that. And it seems to me we have to remand it to the Superior Court because the Superior Court did not address the conditions regarding the internet. It can't possibly be that we could find all these conditions violate his First Amendment rights no matter what, because obviously, first of all, he's a convicted sex offender, so some of it must be, well, it must have to be an individualized, fact-bound determination about which, if any, of these restrictions violate his First Amendment rights. In other words, we're not the right court for that. So it's got to go back to the Superior Court. So to, again, pick up on Justice Henry, this seems very inefficient. You're going to wait for us to write a decision to say, hopefully we agree with you, and then we're going to remand it for a fact-finding on that. We can't possibly, can we, say these conditions on their face are a violation of his First Amendment rights?
Well, I would say, I mean, it took us about 4.5 years to get to the point where we are today. We did paper discovery in the Superior Court already. Initially the parole board didn't want to respond to our discovery. We got a court order saying that they did in fact have to respond to the order. So I would actually say that it would be more efficient if the case were to be remanded back to the Superior Court. All the work has already been done. If we were to file a new case, we would have to...
Okay, sorry, but I don't mean to cut you off. It sounded like you just said you agree with me, that that remanding this might, because I'm now on part 2, you want us to remand it. Are you saying you agree with me that we should remand it to the Superior Court for fact-finding on the individual conditions?
My position would be that the appeals court doesn't have authority to make a declaratory judgment under 231A Section 1. So I think that it would have to go back to the Superior Court. But I would suggest that this court could certainly provide guidance to the Superior Court as it relates to the constitutional issues, which I think are, quite broad, and I would just, I know the court probably is not inclined to address the merits of those claims at this point, but if the court will indulge me, I'll just take a tiny bit of my time here left and just say that they are excessively overbroad and do not serve any governmental interest.
So before you get there, she's going to get up in a minute and argue that we have an inadequate record to even give guidance on the constitutional issues.
Again, I disagree because we did discovery. There's answers to interrogatories. They're appended to my first motion.
She's going to say that relates to the 2020 or 2021 conditions, and now we have these 2023 conditions.
I would take a close look at the answers to interrogatories. Those were intended to be an attack on the Sex A conditions more broadly, not the specific conditions of Mr. Norris. I would also say that, these conditions that Mr. Norris actually received after the first time he was paroled and then after the re-parole hearing or the second revocation hearing, these are derived from the Sex A conditions. A parole officer has merely allowed Mr. Norris, a small portion of the internet, kind of green-lighted one area, but it has not really overtaken the Sex 8 conditions as a whole. So, and I would also suggest that having a parole officer with so much power over an individual's First Amendment rights is problematic in and of itself.
I see no further questions from the bench. Thank you very much for your argument.
Good afternoon. May it please the court. Nicole Nixon, Assistant Attorney General, appearing on behalf of the Parole Board. And if I could just start off by answering Justice Wood's question as to why this court is not the appropriate court to be deciding the constitutional issues in the first instance. I would say that the record is completely inadequate to be deciding these issues. If you look at the complaint, if you look at the pleadings and the claims were pled in the complaint, I would point your honors to paragraphs 94 and 95 of that complaint. That's where the declaratory judgment claims are pled. They're completely tied up in Mr. Norris's conditions. If I could quote, I think paragraph 94 says, "The parole conditions that restricted Mr. Norris's internet and smartphone usage were not reasonably related to the goals of his parole and were imposed in violation of the United States Constitution and the Massachusetts Declaration of Rights." Paragraph 95 says, "The monitoring of Mr. Norris's internet and smartphone usage constituted an unreasonable search and a violation of privacy rights in violation of the United States Constitution and Massachusetts Declaration of Rights." And then when we get to page 34 of the complaint, that's that's Record Appendix 1, page 34, and that's where he's asking for his prayer for relief as to the declaratory judgment claim. He's asking for a ruling that the parole board implemented parole conditions in violation of his constitutional rights and enforcement of unconstitutional conditions was unlawful. And I think if you look at—
I'll go back to where, if we rule in your favor, is there some reason he can't just turn around that day and file a declaratory judgment act claim that's better pled?
I don't believe so, Your Honor. As long as there's sufficient information in that complaint would be a completely new complaint. Again, there has to be sufficient—
His point really is that we're not, the law is not stupid, and that when the parole board has a set of conditions that's so common they have a label, right, that in fact, maybe he could have done a better job, but let's face it, we know what he's trying to get at. Why don't we just cut to the quick and move it along and get to the issue?
Well, Your Honor, respectfully, there's a procedure in place, and there's a procedure in place for a reason, and that's to create an adequate record. And I completely disagree that the record here is inadequate, or is adequate to decide the—
well, we'll have more discovery, but we've got a labyrinth here. I mean, I get he has counsel, but not everybody does, where you're saying, well, you get 60 days to seek review by certiorari, and then if you're going to do the declaratory judgment, you got to say these magic words. And he's like, any reasonable person gets the gist of what he's arguing in the declaratory judgment. Even if he didn't do it perfectly, we know what he's trying to get at, and it doesn't need to be dismissed. We can just get along with it.
Well, Your Honor, respectfully, I would disagree that he's arguing that the reasonable person, and indeed the Superior Court didn't construe it this way, that he was making a broad allegation as to challenging the constitutionality of the Sex 8 conditions. What the Superior Court, I think, correctly construed the allegations in the complaint to be is that he was alleging a constitutional violation based on the imposition of the conditions in his case. And I would point out that the conditions that were imposed in his case are different from what the general Sex 8 conditions are. And if you look at how the claims were argued below, again, if you look at his motion for a declaratory judgment, if you look at his motion for judgment on the pleadings,
But that's where I'm going to take you back then, because this is where it's like, okay, I feel like we're dealing with the labyrinth and the minotaur. Because you're saying, well, it doesn't matter if he can challenge the Sex 8 conditions, because what he really had to have done was sought review by certiorari for his particular conditions. And so as long as in each individual case we just tweak them a little bit, then not one of these guys can just bring the declaratory judgment action against the Sex 8 conditions.
Well, I don't believe I'm making that argument. I apologize if that's how you're construing it. I think that—
I'm legitimately trying to understand what he should have done. He can't, because you're going to, if we go that route, that we've got to look at his individual conditions and we don't look at the Sex 8 conditions, even though they seem like they're imposed on him, then he can't get review now because he's got 60 days to get review. And frankly, he blew it on nobody seems to have caught that he didn't file originally within 60 days of the 20, I'm going to call them 2020 conditions, but now he definitely hasn't filed within 60 days of the 2023 conditions. So his only option, it seems to me, you will say to a Superior Court judge or one of your colleagues, his only option is a declaratory judgment action.
Your Honor, what I'm simply saying is that the allegations in this complaint, which is what the Superior Court looked at and which this court is tasked with reviewing, were insufficient to raise a declaratory judgment claim.
Can I ask on that point very specifically? Paragraph 17. Mr. Norris was subject to general conditions of parole, along with an additional set of sex offender conditions deemed appropriate for offenders classified as Level 1 by the Sex Offender Registry Board, colloquially referred to as the Sex A conditions. True and accurate copies attached as Exhibit B. I read that as a normal person, like he's subject to the sex offender conditions, which are applicable to all sex offender parolees. Isn't that getting us into the ballpark?
Your Honor, I think it gets us more into the ballpark. However, respectfully, I would say that that's insufficient to plead a consistent and repeated violation of constitutional rights. And I say that because there's not a further allegation where it goes beyond his individual case. And I think that's where the problem is. If you look at, I would point your honors to the case of GREANY v. Commissioner of Correction. It's an appeals court case. I cited to it in my brief. I think the language is very clear there that it's not enough to claim a constitutional violation. It has to go beyond, the allegations in the complaint have to go beyond a particular person's case. And I just respectfully disagree that the allegations here were sufficient.
So that's a correct statement of the law, but to Justice Henry's point, one more sentence in here, one more sentence would have indicated that this was a general a problem, and that would have been sufficient? Or how much more do you think this complaint needed in order to pass muster?
Your Honor, perhaps appending some type of policy as to how these conditions are applied generally, where, certain conditions were applied, or whether these general Sex A conditions were applied and there was a blanket prohibition. I would point out again here, too, Mr. Norris was not subject to as to the internet restriction, he was not subject to the generalized Sex A conditions. Those Sex A conditions were subject to modification, and they indeed were modified in his case. So I think
Can you just give me one example? I'm sure, I apologize for not having it memorized, but I'm looking at the Sex A conditions attached as Exhibit B, and there's little initials, and he initials every single one of them. That says to me that he was subject to all of the Sex A conditions for a Level 1 anyway. Are you saying that, in fact, he was not subject to all of those?
Your Honor, he was subject to them. However, the internet restrictions as to what he's challenging in his declaratory judgment count, those were modified by the parole board. They were modified in 2021, and they were modified again in 2023.
They were not part of the Sex A conditions?
So my understanding of how the Sex A conditions work, and again, this is outside the record of this court, but if your honors would like at least my understanding of how they operate, there's Sex A conditions that are generally imposed onto somebody who's a registered sex offender. They're dependent on how they're classified as a Level 1, a Level 2, or a Level 3. However, those conditions are always subject to modification by the board. So they can be, some conditions can be taken away, some conditions can be modified. It's just dependent on the particular parolee circumstances.
When you say his conditions were modified, and again, as Justice Wood has pointed out, it looks as if all of the conditions were going to be applied to him. Were there additional conditions and those were modified, or are we talking about some of the conditions that are already listed in the exhibit that were modified?
Your Honor, I would point, and so again, there's two sets of conditions, so I want to be clear about the conditions.
Okay. All right.
But if we're looking at the 2020 conditions that were originally imposed when he was re-paroled, those conditions were modified in 2021. I would point your honors to the record Appendix 1, 71, 74, 81, 326, 327, 339.
I got 326, 339. Okay, I think I got you.
I apologize. I can go slower.
This is my chicken. Can I say repeat, please?
Yes, sir. I apologize.
Okay.
71, 74, 81, 326, 327, and 339.
Okay.
Those are all portions of the record appendix where there was the modification, where those modifications took place. There may be some duplication in that, but I would point your honors to that part of the record because that's where the modifications in fact took place as to his internet restrictions. Now, when we're talking about the 2023 parole conditions, conditions, which I think is really the more salient conditions at this point, because those are the newer conditions, the ones that I believe that he's currently, subject to. I would point the court to Record Appendix 2, 222, 239, and 276. That's again where those modifications took place. That's the conditions that he's currently under with regard to the internet restrictions.
So he says that his claims under the first set of conditions aren't moot because he was violated and he's now viewed as a violator. What do you say to that?
Your Honor, I would respectfully point out that there's no case law saying that being a parole violator, there's a stigma attached to that. I recognize that cases that I believe my brother cited too, that's in the realm of juvenile delinquency adjudication, I believe a violation of abuse prevention order. I'm not aware of a case where this court or the Supreme Judicial Court has said that the stigma of being a parole violator is sufficient to attach collateral consequences, which would be sufficient then to resolve a moot claim. But even putting that argument to the side, he was revoked on allegations that were more than just violations of the challenged parole conditions or the parole conditions that he's saying are unconstitutional. So even if you were to find that these conditions were unconstitutional, the fact is his parole, there was still sufficient information where his parole still would have been revoked.
So I think I understand you to be saying that his conditions, 2023 conditions, were modified, so they're no longer simply the Sex A conditions. And that's important because this is not something that's applicable to every sex offender. We're outside of the Sex A guidelines. That's the point you're making. And he's challenging, now here's the part that I'm not clear about. Are you saying his challenge is limited to those special conditions, or is it also, does it also include the general Sex A conditions that do apply to him and every sex offender?
Your Honor, the way I read the appellant's complaint, which I think is what we're bound to, is he's challenging his own conditions. I think it's very clear from the language, again, of paragraph 94 and paragraph 95, that he's challenging the conditions that were posed onto him. Right. And I think that's an important distinction, because when you actually look at the constitutional claims that are being raised, they're very fact-specific. A parolee has diminished liberty interest and privacy interest, while they're on parole. And the constitutional analysis really comes down to whether those conditions are reasonable. And the reasonableness determination really comes down to whether the conditions serve the goals of the parolee's supervised release. So again, I think it's a very fact-specific inquiry, especially when you're looking at the claims that were actually raised here.
So back to the violator point, if there's case law that says that violating conditions of probation, has a stigma or can subject one to consequences, why would being a parole violator be different?
Your Honor, there may not be a distinction between a probation or a parole violator, but again, I would point Your Honor to the second point that I made, where in his own case, he was still subject to a parole revocation, even if you take out the constitutionality of the conditions.
On the probation side, if the judge says, there are 3 violations, I'm violating you, and we say one was not properly founded, we send it back. The judge has to say, I would violate him for this separate and independent reason, and this separate and independent reason, and this. They don't ever do that. I really wish they would, but they don't. So if we say, they shouldn't have violated him, or they should consider whether they should have violated him on the internet restrictions, then if this is analogous to the probation violation, I don't know that it is, but then I'd have a concern about just relying on the second thing, which is he violated other stuff.
Well, Your Honor, if you look at the parole revocation hearing, and again, we only have the parole revocation hearing from 2021, I believe it was 2021, the board was very clear as to what they found sufficient to be, what they found sufficient in the record, the specific alleged violations that they found sufficient evidence for him to have violated. They lay that out very clearly. So I believe even if you take the violations as to the challenge conditions away, there's still sufficient information from that parole decision to show that he violated, he would have been violated and he was violated on the other alleged violations.
So this is somewhat the same point, but he's relying on a Supreme Court decision that I'm going to mispronounce now, Uzagbunam versus Przewski, 592 U.S. 279. That he's relying on that case that this isn't moot. I wondered if you'd read that and if you want to share any thoughts you have about it.
Sure, Your Honor. My understanding of, I'm not going to try the name because I'm going to butcher it as well, but my understanding of that case, it was talking about Article 3 standing, and it was saying that, in a case where somebody alleges nominal damages, that the allegation of nominal damages is sufficient to continue on with Article 3 standing. I don't think it's analogous to the situation that we have here.
Okay.
There's no further questions. I would rest on my brief. Thank you.
Thank you both very much. All right, that's the end of our sitting today. Thank you very much to everyone who has helped us out, and the court will stand in recess.
Rise.